Yes.
Permission to mention. ECOM 328 of 2024. In this matter, Lordship, the award debtor have continued requested for time for settlement, but they have continued breach their commitments, and despite several opportunities and several attempt from our side to I will reach the client for reach the award debtor for settlement, but they are continuing as a default. And Lordship, there is an also an apprehension the award debtor may leave the state.
What do you want?
We want matter. I want kindly Lordship this matter listed for tomorrow, and kindly taken by your Lordship.
Not, sorry. Call out the list.
So this is appearing at my instance. I appear for the award holder.
Yes.
But this is an execution case arising out of an MSME award. A
Yes.
Section 34 application was initially filed by the award debtors. My lord knows that under the MSME Act, 75% pre-deposit is a mandate of the statute. Without that, the Section 34 cannot be maintained. Section 34 application dismissed. Admittedly, they have not taken steps to have it restored or to comply, because in the Section 34 also, there was a direction for them to deposit that 75% amount. No compliance, it's been dismissed. Thereafter, we filed this execution case. It's an award of 2023. My lord, there was an interim order that's been passed by a coordinate bench, my lord, restraining the award debtor from operating its bank accounts without setting apart an amount of rupees 18 crores. Today, my lord, GA1, my lord, will find from the list. My lord will kindly have GA1. Lord, page 8 is the award. I'm not taking my lord to the entirety of the award. My lord will kindly come to the interim order that was passed, page 22. Page 22, my lord will find the interim order of 22nd July 2025. Here, my lord will kindly see the submission of the award debtor, Mr. Subha, my lord, the second paragraph. Mr. Subha submits that the respondent does not have the authority to make payment beyond rupees 1 crore. Now, this is their contention. As such, 75% of the awarded sum could not be deposited. The application under Section 34 of the Arbitration Act was dismissed on account of the non-deposit of the amount mandated by law. He submits that payments cannot be made because discharge and satisfaction of the award would also involve dealing with cash beyond rupees 1 crore. The GTA has written to the state government. Under such circumstances, the award holder, having made out a good case for execution of the award, deserves to be secured pending final discharge and satisfaction of the award. Following bank accounts, my lord, are remain attached to the extent of rupees 18 crores. My lord, this order has been continued. Today, the only difficulty and why we've been constrained to mention, my lord, this is an award of 2023. The award debtor has taken a stand that it is apparently unable to make payment, or rather, they unable to make the positive action of discharging the award. But my lord, my submission is today, this honorable court is empowered to, my lord, direct this amount that's remaining attached. 18 crores is also not the amount. All these bank accounts, we've taken instructions from the bank. My lord will kindly have once page 29. Page 29 is the information furnished by the central bank. An amount of rupees 13.29 crores is lying in these bank accounts, which are attached. So even as on date, the entirety of the awarded sum, or rather the sum that was due as on July 2025, is not secured. My lord, I have two prayers before, my lord. In GA1, my lord, in prayer B of the notice of motion, master summons, I'm sorry, prayer B of the master summons, I have, my lord, sought for a transfer to be effected from the amounts that are lying due, or rather are maintained with the bank accounts, to my client's bank accounts. My lord, today the award debtor cannot oppose this prayer because the award debtor is saying it cannot under authority of law, that is their contention, transfer this amount voluntarily. Now, I am praying for an order of court to transfer at least the sum of rupees 13 crores that are lying due and payable to my client's bank account. There is no prohibition in law in that regard. Number two, my client is in dire straits because of these financial defaults. I am an MSME unit. I am facing demands from banks. I have been declared, my bank account has been declared as a non-performing asset, but I am facing impending financial doom. But without this amount being discharged, my lord, my clients will be put to serious prejudice. My lord, I'm only praying for two things, my lord. My lord will kindly direct the award debtor to disclose on affidavit other bank accounts which they have, Yes, that's already attached. My lord, we've also taken out this application. We found some other bank accounts which are lying in the name of the award debtor. We're seeking attachment to fulfill that 18 crores amount that was directed by this honorable court to be attached, because 13 crores today is lying. Secondly, my lord, as to this amount that is lying attached in these bank accounts to the extent of rupees 13 crores, my lord will kindly direct the bank manager or the branch manager to directly transfer this amount in my client's favor. There is no subsisting challenge to the award. There is no ground for the award debtors to evade this payment now, even if the award
I
debtor does
submit,
not
your
do
lordship.
so.
Lordship, this is a very unfortunate case, your lordship. What has happened in this case is the actual amount which was due to my learned friend's client was 42 lakhs only, your lordship. Rest is all interest, by way of interest, lordship. Now, before the NSME,
Whose fault is it?
yes,
If
your lordship.
the interest is accruing, whose fault is it?
No,
Whose
your lordship.
fault is it?
But anyway, your lordship, that is the
Award is for how much money?
Award
I don't
is
know, your lordship. That was
42
about
was the principal. This is an MSME award 2020. It's been calculated from
Just
2018
imagine,
to
42 lakhs
42
award,
lakhs.
and
My lord.
today the government is
My lord.
supposed to pay it.
18 crores, your
That's
lordship.
your fault.
It is not my fault, your lordship,
Whose
because
fault
I
is it?
went to the what is that? Sorry, NMSC, sorry, lordship. That lower court, whatever it is, your lordship. I'm sorry.
MSME council. my lord.
MSM, lordship. Their their application was heard ex parte. The order was passed ex parte, lordship. Against that, I had to come to High Court, your lordship. Now in the High Court, their section 90, section 19 was staring at my face, your lordship. Now they had given the decree for that amount also, your lordship. Their interest part also, your lordship. Now GTA is a small this thing, your lordship. It is a small government has formed this in Darjeeling, your lordship knows that very well, lordship, out of accord, your lordship. Now the financial limit of the GTA is only 1 crore, lordship. Beyond that, it has to come to state government, lordship. Now GTA is all strapped with the fund, your lordship. Strapped with the fund, they don't have any fund, your lordship. And in fact, it is only the your lordship kindly sees, it is only the public health engineering department.
So they'll
Now what
sell
we
all
have
your
done is,
properties, they'll recover it.
My lord.
42 lakhs, you make it 18 crores. It's all your fault, sir.
but
It's
I must
all-
get chance to, but I must get chance to
Who stopped
rebut
you?
that, your lordship.
Who stopped you?
No, at that time, your lordship, what had happened was, your lordship, on that date
Nothing
we had
had
gone
happened.
there.
It is only you're not being diligent and nothing else. It's public money which
No,
is
your lordship,
being.
no, your lordship. What had happened at that time, your lordship, kindly consider. That was this period, COVID period, your lordship.
Anyway, we are in
That was
execution.
COVID period, your lordship.
Sir, we are in execution. We are not hearing your 34.
Very well, lordship. Now, what has happened in this case is this, your lordship. They have attached 6 accounts, your lordship, here. 6 accounts which are in page 7, your lordship. I have given the affidavit of this thing, your lordship. Assets. Now they have attached all the bank accounts here, lordship, which belongs to other departments also, your lordship. As a result of which, your lordship, they have not been able to pay the salaries of the employees there.
Very good. Secure them the money. They will release all.
We have your lordship written to the state government, your lordship.
Same
They are not
thing,
taking any step.
I'm not concerned with your internal problems, sir. I'm only concerned with the award. Your conduct doesn't show any confidence. And you're it's so sad to see this. 42 lakhs goes to 18 crores,
18 crores.
all because of you.
No, your lordship, they have calculated the amount right from the beginning.
That's the award.
Right from the
That's
beginning.
the award. They have not done it. You have failed to do it.
We
You
could
have
make
not
our
taken
submissions,
any
of course,
action.
lordship. We could make our submissions there, of course, lordship. That is our fault.
That is your fault. Look at what you're doing to public money. And you stand here smiling, wasting public money from 42 lakhs to 18 crores.
Sorry for my facial expression, lordship.
Not facial
It
expression.
is. I'm not
This
smiling, your
reflects on
lordship.
your conduct
I'm not.
also.
I'm not smiling, your lordship. I'm not
It
smiling.
reflects on your conduct. You have done nothing. Your 34 is also dismissed. What steps have you taken to restore it? What steps
We
sir,
have- we have,
taken to restore your 34?
We have filed an application for restoration, lordship. Restoration application is there.
The
Still
When did you file it?
we have filed it, your lordship, on
We'll have it tomorrow. Let them come with all the.
Yes, Lord.
You find out when did you file it, get all your dates clear.
Yes,
Fine.
I'll come back tomorrow.
Lord, only one submission, even if they filed it, my lord, they've not complied with the pre-deposit. Without that, it can't be maintained. Even the pre-deposit of 75% has not been made despite orders of court. There's no question of them
You're not
even
taking
seeing to
the payment. You know the MSME Act. You have to make the payment under Section 19. You have not even done that. How will it get restored?
Lordship, kindly direct the officer from the department to come here, Lordship. They think that we are not representing them
Lord,
enough.
we'll
Here.
do so. Lord, I'm kindly
be-
direct a
let
personal
them come
appearance.
here,
They
Lordship.
have to come.
Personal appearance, Lordship.
Who's the
let them
concerned
here, Lordship.
person?
Executive Director. My lord, Executive Director, Public Health Engineering Department.
Public health.
And my lord, also from the Finance Department, since this is a state entity, my lord, Finance Department, I don't know who the appropriate authority is. My lord, kindly direct
Let them
personal
come here,
presence.
Lordship.
I agree. হ্যাঁ, ঠিক আছে। আরে রিস্টোর কি করে করবে টাকা? হ্যাঁ, ঠিক আছে। হুম, হুম, হুম। ঠিক আছে, ঠিক আছে, ঠিক আছে।
Who would be the concerned person?
I think the executive director, Lordship, PHE, GTA.
Now, why should I call him? What will he do?
My lord, today this is an
Yeah.
award debtor who is in blatant disregard. My lord, despite an order for securing 18 crores passed in July 2025, they have not done so. My lord will either direct my humble prayer, my lord.
Look at you. You are the lucky one. From 42 lakhs, you
My
make
lord,
it
it's an
to 18
MSME
crores.
unit. My lord, it's an MSME unit. Today we had approached, my lord, a long while back. It's an MSME unit. The act provides that it has to be compound interest at 3 times the bank rate. If they had made my payments, and this is a dispute quay, my lord, admitted supplies. We had supplied material. It's not as if we were unjustly enriched. We had supplied materials. If they had cleared our bills on time, there's no question of anything accruing. Lord, today our client or rather my client cannot be put at fault for this, my lord. You kindly appreciate. My lord will kindly consider my prayer. I've sought prayer be of my master
No,
summons.
that can't be done.
My lord, here at least a portion, my lord, my
Not at
client
all.
is in dire financial
Impact
state.
was
my
of
lord.
24 crores, Your Lordship, out of which, Your Lordship, only 42 lakhs remains, Your
So
Lordship.
that can't
So why
stand.
That's no longer the case, sir.
No, not that, Your Lordship. But that is the
And you have done
fact, Your
nothing about it.
that is the fact, Your Lordship. Your Lordship.
Totally shameful conduct of the department. Shameful conduct.
We would have even been willing to, my lord, amicably settle the matter. They have not taken any steps. We would have even been, if any proposal had come from the auditors, even that we would have considered. But we can't be out of pocket, my lord. It's a contract a long while back. We've been out of pocket for more
Why
than
don't you
10
settle
years.
it?
If Your Lordship wants,
My lord, without a direction, my lord, this is the government. Without a direction, nothing will happen. My lord will kindly appreciate my
I
predicament.
can send it for mediation.
Mediation will not,
yes, Your Lordship.
that will not solve the issue, my lord. Humbly, my lord. A mediation before outside of court, my lord, that won't be. If their officers seriously meet with us, try to come to a practicable solution, my lord, we would be completely agreeable. We have no difficulty. But that's not been coming forward. But mediation, the matter will just drag on, and thereafter again no solution. And my client will be out of pocket still. We'll still be, my lord, suffering. We kindly direct them to come personally. Let them explain what their rationale is for their entire negligence that is evident from the face of record. let them come with a concrete proposal, my lord. Mediation, sending for mediation with a blanket order, my lord, that will not, if they come forward with a concrete proposal that this is the amount we are willing to pay, well, my client can at least consider it. At least we'll have some money in our pockets at the very least.
Take down. Learned counsel for the petitioner states that the awarded amount of rupees 42,41,922 as principal amount has accumulated to rupees
24 crores and what, my lord. I've stated that specifically.
24 crores 37 lakhs 35,427
2417.
since the said principal amount has accrued an interest and and the said amount has accrued to so and so with interest. That's it. Full stop. Learned counsel for the petitioner states that the petitioner is agreeable to an amicable settlement if the respondent is ready to make an offer. Full stop. It is noted that the GTA, the respondent, has failed to has not been diligent in pursuing the proceedings, and the Section 34 petition filed against the award has been dismissed since the respondent could not pay the requisite statutory fees under Section 19 of the MSME Act. Full stop. It is noted that the amount has accumulated only due to the fault of the GDA in not pursuing the matter in a diligent manner, and that the officer concerned have failed to pursue the proceedings diligently. Let the Executive Director, Public Health Department, be present in the court on the next date of hearing on Monday to explain the steps taken by them in pursuance of the award, and also to come up with any figures for an amicable settlement as indicated by the petitioner. Full stop. It seems that the respondent has been dragging its feet, and thus the awarded sum of rupees 42 lakhs 41,922 has accumulated with interest to rupees 24 crores 37 lakhs 35,427. Full stop. It's a sorry state of affairs to see that the government department are are unnecessary enriching the award holder by not taking appropriate steps, and the interest keeps accumulating due to fault on the part of the department. We should recover these kind of money from selling all your properties, from the salaries of all your officers.
State government law has been made in such a way, Lordship. State government has got all the financial power, Lordship.
Sir,
From beyond 1 crore.
when did you write to
coffers are
the,
empty, Lordship. The coffers are. I'm told that coffers are empty. They're helpless.
when did you write to the state government?
Empty, but
It was written, Your Lordship, on 31st of July, Your Lordship.
Now, we are talking about when was the award passed?
2023.
23.
23. Lordship.
You're writing now. List on Monday.
My lord, one further prayer, my lord. The interim order is expiring on 31st. My lord, will extend-
Monday.
My lord, 30th. It's expiring on Sunday, my lord. It's till the end of November. My lord,
All right,
kindly
we'll have it Friday first matter.
My lord, this Friday.
Yes, Friday.
My lord.
This
Obliged.
Friday.
Yes, matter will appear.
Oh.
Obliged.
I'm for the respondent, my lord.
Lordship,
This is my application under section 29A of the Arbitration and Conciliation Act. My lord, I'll give your lordship the timeline. My lord, the pleadings were completed on the 16th of November 2022.
When was the arbitrator appointed?
My lord, the arbitrator was appointed on the 1st of September 2021. The order is at page 58.
Just a minute. 1st September.
Yes, my lord. I'll be candid, my lord. Prior to this, there have been 2 extensions obtained under section 29A of
Just
the
a minute.
Arbitration and Conciliation Act.
Just a minute.
Yes, my lord.
Page 58 is application regarding de facto termination mandatory. When was the first arbitrator appointed?
My lord,
Yes,
on
my lord. The
13
first-
December 2019, the first arbitrator was appointed.
13 December.
Yes. Yes, my lord.
Correct
He
date.
thereafter. Yes, my lord. He thereafter recused himself.
Yes.
That letter is there of 19th June 2021, my lord, at page 49.
Yes.
Thereafter, the next relevant order, my lord, is at page 51 on, my lord, 20th of July 2021. Learned Senior Advocate Mr. Sham Sharkar was appointed as the substitute arbitrator. He, however, expired shortly thereafter on the 27th of July 2021.
All right.
Thereafter, my lord, the order I showed your lordship at page 58. The present tribunal was constituted by the order of 1st September 2021.
All right.
22.
I beg your pardon, my lord, 2022. I apologize.
Yes.
My lord, pleadings were completed on the 16th of November 2022 as pleaded at paragraph 20 of my application.
Readings completed on
16/11/2022, my lord. So, my lord, 12 months therefrom was to expire on the 16th of November 2023. My lord, by 6-month consent, the mandate was extended up to the 15th of May 2024.
Yes.
Thereafter, my lord, 8th July 2024, this honorable court was pleased to extend by a further period of 6 months up to 15th November 2024. That order is at page 67 of my petition.
Yes. Then the
And
second one.
thereafter, yes, my lord, 18th November 2024 at page 80, extended for a period of 1 year, expiring on 18th of November 2025.
Yes.
My lord, the stage
Drop
is,
it.
my lord,
Yes.
the stage is, my lord, final hearing. My lord, the claimant is well underway with its submissions in the final hearing, my lord. Witness action has been completed. 2 witnesses examined by either side. And my lord, we are at the stage of final hearing. So I was beseeching your lordship for an extension, my lord.
My lord, I have no
My-
objection. My lord, the only
Take up.
thing is, my lord, my learned friend is appearing for the claimant. I am for the respondent counter claimant. I also have a substantial counter claim. My lord,
Yes.
they have not completed their submissions yet. Thereafter, I have to, my lord, make my submissions. So, my lord, perhaps 6 months time, my lord, is perhaps not, my lord. If my lord kindly grants us, my lord, a year's time, my lord, then
6
because my
months is
lord,
what he's asking for. How can I give you a year's time?
Petition page 17 are my prayers, my lord.
That's what he has asked for.
that's,
My lord, the records are voluminous. It is a
yes, my lord, there are voluminous
It-
records.
He's asking for 6 months, madam.
That is true.
very
That is
well,
true.
my lord.
That's his
We will try our best to finish before that.
Take down. The present application has been filed by the petitioner under Section 29A of the Arbitration and Conciliation Act 1996, seeking extension of time for conclusion of the arbitral proceedings and for publication of the award. Full stop. It is the case of the petitioner that this court-wide order dated 13/12/2019 appointed Mr. Malay Kumar Ghosh as the sole arbitrator to adjudicate the dispute between the parties. Full stop. However, the said arbitrator, via letter dated
19 June 2021.
19/6/2021, expressed his inability to continue as an arbitrator and had withdrew from the reference. Full stop. Hence, this court-wide order dated 27/2021 terminated the mandate of the earlier arbitrator and appointed Mr. Shyama Prasad Sarkar as the sole arbitrator. Full stop. However, unfortunately, the said sole arbitrator expired on 27/7/2022. Full stop. Further, on the application of the petitioner, this court-wide order dated 1/9/2022 appointed Mr. Utpal Bose, senior advocate, as the arbitrator. Full stop. The pleadings were completed on 18/11.
16/11, my lord. 16/11/2022.
The pleadings were completed on 16/11/2022. The mandate of the tribunal expired on 16/11/2023. Full stop. Thereafter, with the consent of the parties, the mandate was extended till 15/5/2024. Full stop. Thereafter, this court-wide order dated 8/7/2024 and 18/11/2024 extended the mandate of the arbitral tribunal by 6 months and 1 year respectively. Full stop. Thus, hence now the mandate of the arbitrator has expired on 18/11.
18th November
18th,
2025.
18/11/2025. Full stop. It is stated by the learned counsel of the petitioner that the matter is at the stage of final arguments. Full stop. Learned counsel for the respondent states that there is a counterclaim which has been filed by the respondent and they are at the stage of recording of the evidence.
My lord, evidence is
No, my lord,
concluded. My learned friend
Final arguments in both.
making his
Final arguments in
submission
both.
All right.
for arguments, and thereafter we will make our submission.
Learned counsel for the respondent states that she has learned counsel for the respondent states that she has no objection to the present application being allowed. Full stop. The arbitral tribunal has held more than 43 hearings and has recorded the evidence, and the present proceeding is at the stage of final hearing. Full stop. Upon consideration of the record, this court is satisfied that there are undue or unwarranted delay attributable to the learned sole arbitrator in conducting the proceedings before conducting the proceedings. Full stop. Having regard to the stage of the arbitration and in the interest of justice, the mandate of the sole arbitrator is extended further for a period of 6 months from today. Full stop. Who's the arbitrator?
Mr. Utpal Bose,
Mr.
learned
Utpal
senior
Bose.
advocate.
The learned arbitrator is requested to make all reasonable endeavor to ensure that the arbitral proceedings are concluded and the award is published within the extended time period. Full stop. With the above direction, the present petition stands disposed of.
Grateful, my lord.
Extremely grateful.
My lord, I am for the petition. My lord, 29A application, my lord, on 14/9/2022, my lord, proceeding initiated with the first meeting of minutes, and then, my lord, since, my lord, there was a
Where's
mutual,
the service
my lord,
respondent? Have you served them?
my lord, I'll have to ascertain. I
Where's
have
the affidavit of service, sir?
to, my lord, I shall serve and come. I shall serve and come.
Not
Much
today.
let this be, my lord, in 1 week time, my lord. Within the meantime, I shall serve and come.
Not today, keep it after 1 week.
Much obliged.
Yes, Mr. Banerjee.
Yes, no. My lord, now, my lord, yesterday I showed to my lord the facts of the case, my lord, whereby, my lord, is, I may term is that one of those rarest cases, my lord, we come across, where, my lord, the adjudicating authority takes up matters against the same clients, my lord, during the pendency. Not one, but four. Now, my lord, most importantly is that I can produce the records if your lordship wants, my lord. All these four, my lord, applications where he is appearing against the claimant are identical matters. Identical matters, except, my lord, that the party is different. Same agreement type, same everything. Facts are the same. Now, my lord, there are two issues which lordship, my lord, my learned friend has raised. Is that, my lord, since there is a 12 and 13 file which has been rejected, and I showed the grounds, my lord, my remedy, my lord, is in, my lord, under the provisions of section 34. Now, my lord, reading the act itself and the intent is very clear. My lord, 12 and 13 is a proceeding before the arbitrator, where, my lord, the inability of an arbitrator under the provisions of schedule 5 and 7, my lord, comes in.
Yes.
But 14, my lord, is a proceeding before the court where, my lord, de jure de facto, my lord, if I can show to my lord, the arbitral proceedings has to be terminated. So there is a startling difference between the two.
Yes.
Because 14, my lord, will kindly see, is not an appealable order.
Yes.
14, my lord, does not fall under section 37. And therefore, my lord, 14 is something where, my lord, the arbitrator even cannot, my lord, adjudicate. It is only the court where, my lord, has the jurisdiction to adjudicate, where he becomes completely ineligible to perform his duties. And a substituted arbitrator can be appointed under 15. Now, my lord, that is exactly why I said, my lord, that I have not come up under an appeal or, my lord, under any orders of 12 and 13. I only
your application, your petition is only under 14.
Yes, 14 and read with 15.
Read with 15.
Because, my lord, obviously, my lord, I would have also tried this, my lord, that I would show that there is a 12 and 13 rejected, so they have come up with 14 and 15. My lord, irrespective of that, I can always come up in 14 and 15 if I can show to my lord that it is barred under the law. Now, my lord, why I say it is barred under the law is that, my lord, a person cannot, my lord, at the same time adjudicate and also, my lord, sit on a cause against the same clients, my lord, as a my lord, counsel. But this is very rare because, my lord, most of the cases I was going through of the Supreme Court, my lord, are all retired judges. My lord. And therefore, my lord, this question of appearing for the clients doesn't appear, my lord, doesn't come across. But, my lord, this is, as I say, one of the rarest cases where, my lord, a practicing counsel, my lord, is involved. I have no quarrels with him, my lord, because, my lord, it may happen by mistake. But, my lord, I can also show, my lord, in two other matters this has happened where they have, my lord, voluntarily recused. Once, my lord, it has been. And, my lord, most importantly in this case, disclosure was to be made by him. It is only, my lord, that, my lord, after we requested,
Yes.
the disclosure is made. Disclosure was not made otherwise.
Initially, the disclosure
Initially
you
was
had
made,
agreed
we
to
said
it,
that
and
we
then
have no
subsequently
problem.
You had moved an application seeking
Correct.
further disclosure.
Initially was made, my lord, he said that past he has appeared. So we said that is not a problem. And one matter is appearing arbitration. We said that is all right. But, my lord, post the reference being entered upon,
He has
and
appeared
around
for-
6 months' time, he, my lord, took up other matters against the same respondent in respect of same type of, my lord, agreement. Same identical type. If your lordship wants, I can produce those matters also, my lord. Identical agreement.
You have mentioned it
Yes.
in para 10.
Yes, my lord. Those are mentioned here, my lord.
4 matters which you have.
Yes. Kindly seize, my lord.
It's there. It's page 5, para 10.
Yes. And, my lord, he has himself given the AP numbers also. Kindly seize, my lord, his disclosure. He has given the AP numbers which are probably pending before my lord only. So that is why I say, my lord, that, my lord, I have to only show before my lord that there is under the law a bar not to, my lord, proceed with such, my lord, mandate. Because I am sure, my lord, today, my lord, my learned friend is opposing it. But, my lord, had it been, my lord, considering the, my lord, the professional ethics, my lord, he would also agree with me, my lord, that a person who is, my lord, adjudicating, my lord, the same agreement cannot, my lord, take up matters during the proceedings. If the proceedings terminated, award passed, I can understand. But during the proceedings, my lord, it is impossible. And no client would like to go to a judge, my lord, who, my lord, has passed an award and would, or an order, and is also sitting in appeal. And that's not possible. It's like that only, my lord. The other way around, he is adjudicating and, my lord, contesting matters against the same, my lord, litigant in court. And that's admitted by him. And I was checking the minutes, my lord. The directions, perhaps, for, my lord, the evidence to be taken is sometime in August. We wrote to him in September, and obviously thereafter, my lord, we have taken time because we did not want to proceed before him. So, my lord, as I said, my lord, kindly takes, my lord, 14 once, and then I'll show, my lord, the schedule. Judgment hour. Judgment hour. Oh, yeah. 8. My lord, kindly sees the heading, my lord, of 14. Failure or impossibility to act. My lord, I am on this part. Impossibility to act, my lord. A person, my lord, who is a judge, in this case, my lord, adjudicating, if he is, my lord, a counsel against the claimant, that too, my lord, is against the claimant. At the same time, I would say, my lord, this is an impossible situation for him to act as a judge. But because we are humans after all, my lord, it will cross our mind. If I am appearing against, my lord, a litigant, my lord, I will always try, my lord, to find out something always against that, my lord, litigant. Correct or incorrect, my lord? I would try to. And, my lord, at the same time, if I sit as a, my lord, adjudicating authority against that litigant only, my lord, that would obviously play in my mind. It is impossible to, my lord, be so unbiased humanly. Now, my lord, I am on this part, or impossibility to act under section 14. Now, my lord, kindly sees, apropos this, the mandate of an arbitrator, the word is shall. So it is automatic should be. Shall terminate, and he shall be substituted by another arbitrator if he becomes de jure or de facto unable to perform his functions, or for other reasons fails to act without undue delay. Now, my lord, I would also fall under the second part of A. My lord, he has failed to act without undue delay. He should have on his own terminated the mandate. He should have on his own done so. And he has not done so. That is why I have to come before my lord under de jure and de facto. Because 14, as I said, my learned friend pointed out, my lord, he has to wait till 34. But 14 is completely different, my lord. 14 has got nothing to do with 12 and 13. I have a remedy, my lord. I can, if I lordship, my lord, turns me down on such facts, I have to wait till 34. But my lord, the fact is that 14 is completely different. 14, if
You
I
have to
can,
wait for the award to go in 30.
yes, in 12 and 30. But my lord, in 14, if I can show to my lord that it is impossible for him to act, then my lord, I have a right, my lord, for his termination to be, my lord, taken, my lord, to be granted by the court. And my lord, 14, he cannot do anything. 14 powers are not with the arbitrator. Kindly sees, my lord, the 14 heading and the second part.
Yes.
Now, my lord, kindly sees, my lord, the commercial aspect also, my lord, in such a matter. Because these are all commercial matters, my lord. Arbitration, my lord, is not, my lord, something, it's a luxury litigation in an aspect, my lord. Now, my lord, kindly sees, my lord, if today I have to go back to the same arbitrator, let us presume, my lord, lordship turns down my application. So, my lord, I would be proceeding before an arbitrator knowingly that he is appearing against, my lord, those, my lord, litigants who are the claimant in court. I would have understood this also, my lord. He would have recused from those matters after, my lord, disclosure to us. That also he has not done. He's still pursuing those matters before the court. So, my lord, if that be so, then I will be proceeding before an arbitrator knowingly somewhat his frame of mind, and, my lord, wait for a 34. Kindly sees the cost also, my lord, of the litigation. Because, my lord, in 34, I will take the same grounds. Because I have to, because I have taken it, because, my lord, I cannot assume today, my lord, what will happen in the award. It may be in my way or his way. But, my lord, let us take, my lord, the worst. I have to take the same grounds. And in such a situation, kindly also considers the commercial aspect. And it is not that, my lord, my lord, if today respondent would have come up, I would have understood. He said the right thing that, my lord, he is the claimant. The carriage of proceedings is with him. So, my lord, I have come up. The claimant has come up. Now, my lord, if today another arbitrator is appointed, impartial arbitrator by my lord, of my lord's choice, my lord, nobody is prejudiced. Nobody is prejudiced. From this stage itself, to cut the cost, even I can understand my learned friend saying that we have proceeded to an extent. From this stage, if we proceed, my lord, not afresh, nobody is prejudiced to that extent. Now, my lord, apropos this, kindly considers one judgment of a recent times on biasness passed by the Honorable Supreme Court, my lord, a full bench judgment of 2025 4 SCC 641, Central Organization for Railway Electrification and ECI, my lord. This is, my lord, a judgment on the unilateral appointment, but, my lord, the biasness, my lord, in Indian courts has been spelled out here. My lord, kindly comes to first paragraph, my lord, 32. But kindly takes, my lord. Under the Arbitration Act, the mandatory provisions must be deduced from their content. That's exactly why I was, my lord, trying to, my lord, show to my lord section 14, separate from 12 and 13. For instance, the use of the phrase unless otherwise agreed by the parties is an indicator of the fact that the provision is derogable because it gives priority to the agreement of the parties. In contrast, the use of the word shall, that's the word in, my lord, section 14 I harped upon, in a provision is an indicator that the legislature intended to give it a mandatory effect. Yes. So once I show it to my lord, it automatically flows that it should be terminated. However, the use of shall is not the sole indicator to determine the mandatory nature of a provision. The provision must be interpreted by having a regard to its text and the context to determine its nature. Now, my lord, apropos this, now kindly comes to, my lord, the part where the Supreme Court deals with biasness, my lord. So that's how paragraph. Right. My lord, kindly will come to paragraph 76. It's quite a longish judgment, my lord. Kindly comes to paragraph 76. The heading, my lord, is F. The principles of natural justice principally consist of two rules. No one shall be a judge in their own cause. No decision shall be given against a party without affording a reasonable opportunity of being heard. Adherence to the principles of natural justice is a facet of procedural fairness. A decision made by the state to the prejudice of a person must be after following the basic rules of justice and fair play. The principles of natural justice are applied because administrative or quasi-judicial proceedings can abridge or take away rights. Application of the principles of natural justice prevents miscarriage of justice. Natural justice has both an intrinsic and an instrumental function. The intrinsic function values natural justice as an end in itself.
Just a minute.
Yes, ma'am.
Easy one. Yes.
Yes, ma'am. My lord, the intrinsic function values natural justice as an end in itself. It values natural justice as an essential feature of fairness. In its instrumental element, the natural justice is viewed as a means to achieving just outcomes. The principle of nemo judice is based on the precept that justice should not only be done, but manifestly and undoubtedly to be seen to be done. The principles of nemo judice applies to judicial, quasi-judicial and administrative proceedings. An adjudicator should be disinterested and unbiased. Kindly sees the language, my lord. An adjudicator, here, my lord, he is not a judge, he is an adjudicator, should be disinterested and unbiased. Undoubtedly, my lord, if he is doing matters against my client, he is never disinterested. He is an interested party, my lord, against my client. Now, my lord, kindly sees a bias is a predisposition to decide for or against one party without proper regard to the true merits of the dispute. Now, my lord, apropos this, the Supreme Court, my lord, has spelled out what is, my lord, the likelihood of bias and Indian approach to bias. But prior to that, my lord, kindly comes to paragraph 89 once, my lord, which, my lord, shows the test for real likelihood of bias. My lord, kindly comes to 89 once. The heading is, my lord, automatic disqualification. Bias is generally classified under three heads. Legal interest, which means a judge is in such a position that biased must be assumed. My lord, I here read judge as an adjudicator. And my case is that this is one of those rarest cases where it is assumed that, my lord, he is biased. Then, my lord, pecuniary interest, I am not on that, and personal bias. Now, my lord, here personal bias would also come in because he is acting as a counsel as against the litigant, as against my client in 4 other matters at the same time. A pecuniary or proprietary interest, however small, automatically disqualifies a person. A person who has an interest in the outcome of an issue that is to be resolved would be acting as a judge in their own cause. Now, my lord, I stop here. Definitely, my lord, he has an outcome in the issue in the matters that he is appearing against me before, my lord. He has. Because, my lord, as a counsel, I am, my lord, today appearing for a litigant.
Let's keep it on bias. It's much better.
Yes, my lord. So, my lord, I'm not on the, my lord, financial part, but an interest in my lord, having a matter before my lord heard out and having a, my lord, result out of it. Now, my lord, kindly sees. The question is not whether a judge has some link with the parties involved in a cause before the judge, but whether the outcome of that cause could realistically affect the judge's interest. This principle has been authoritatively stated by the House of Lords in Dimes versus Proprietors of the Grand Junction Canal. In that case, the Lord Chancellor decreed in favor of a canal company in which he held substantial shares. The House of Lords observed that the principle that no person should be a judge in their own cause is not to be confined to a cause in which he is a party, but applies to a cause in which he has an interest. And the second part, my lord, squarely falls with the facts of this case, my lord. Now, my lord, kindly comes to, apropos this, the likelihood of bias, my lord, which is at paragraph 92.
Yes.
The nemo judice rule may be applicable where a judge's conduct or circumstances give rise to an apprehension of bias. But kindly mark these words.
Yes.
In such situation, the judge does not have a financial or cause-based interest. This is identical to our case. He may not have a financial or cause-based interest, but he has, as a counsel, he has definitely, my lord. But still, I go to that extent in the outcome of the dispute, but provides benefit to a party by failing to be neutral and impartial. The determination of bias does not depend upon actual proof of bias, but whether there is a real possibility of bias based on the facts and circumstances. And that is why I said, my lord, it is impossible for a human being at the same time to, my lord, appear against a client and to adjudicate for the client. And my lord, we see in everyday matters, my lord, if in any way the honorable court is connected, the recused matter at the threshold only. But I am on this, my lord, real possibility of bias based on the, my lord, facts and circumstances. Now, my lord, there is an example. I am not on that. Now, lord, kindly come to the Indian approach of bias test, which is, my lord, kindly comes to page 105, paragraph 105. My lord, subsequently, the decision in PD Dinakaran versus Judges Inquiry Committee traced the evolution of bias test under Indian jurisprudence to state the following principle. To disqualify a person from adjudicating on the ground of interest in the subject matter of lists, the test of real likelihood of bias is to be applied. In other words, one has to inquire as to whether there is a real danger of bias on the part of the person against whom such apprehension is expressed, in the sense that he might favor or disfavor a party. In each case, the court has to consider whether a fair-minded and informed person, my lord, kindly mark these words of the earlier judgments, fair-minded and informed person, having considered all the facts, would reasonably apprehend that the judge would not act impartially. To put it differently, the test would be whether a reasonably intelligent man, fully appraised of all the facts, would have serious apprehensions of bias. And that is why I said, after the discovery, if he would have recused himself even from the 4 matters he is appearing, I would have not come before my lord. That has also not happened. Now, my lord, kindly sees, my lord, apropos this, my lord, paragraph, my lord, 107. Although there has been vacillations about the test in England, the Indian courts have been largely consistent in their approach by applying the test of real likelihood of bias or reasonable apprehension of bias. Recently, the court has used the real danger of bias test. However, the above discussion shows that there is no significant difference between real danger of bias test and the real possibility of bias test if the question of bias is inferred from the perspective of a reasonable or fair-minded person. This court has consistently applied the test of real likelihood of bias to determine arbitrator bias. In HRD Corporation versus Gale, the court explained the application of real likelihood of bias test to determine the issue of arbitrator bias thus. As has been pointed out by us herein above, the items contained in the schedule owe to their origin to a IBA guidelines, which are to be construed in the light of general principles contained therein, that every arbitrator shall be impartial and independent of the parties. Here, my lord, definitely is not independent of the parties. In this case, independent of the parties at the time of accepting his or her appointment. But my lord, 12 says that throughout he has to give a disclosure till he passes the award. Doubts as to the above are only justifiable if a reasonable third person having knowledge of the relevant facts and circumstances would reach the conclusion that there is a likelihood that the arbitrator may be influenced by factors, as I said, my lord, may be influenced by factors other than the merits of the case in reaching his or her decision. This test requires taking a broad, commonsensical approach to the items stated in the 5th and 7th schedules. This approach would therefore require a fair construction of the words used therein, neither tending to enlarge or restrict them unduly. In the state of Haryana versus GF Toll, the court had to decide whether a retired government employee could be appointed as an arbitrator by the state government. Justice such and such, writing for the two judges bench, observed that the test to be applied for bias is whether the circumstances are such as would lead a fair-minded and informed person to conclude that the arbitrator was in fact biased. It has been held that the Arbitration Act does not disqualify a former employee from acting as an arbitrator, provided there are no justifiable doubts as to their independence and impartiality. Thus, in India, the sanctity and integrity of the arbitral process are held to be same standard of bias as that applicable to judicial authorities. My lord, if that be so, then my lord, squarely, my lord, he has to be terminated. Because my lord, if my lord, this applicable, if this is applicable to judicial authorities, I don't think, my lord, any judge could have done this. My lord, in a judge's case, it would be, my lord, passing an order and sitting in appeal, taking up the appeal bench. So, my lord, it is impossible if the law as laid down by the Supreme Court is to be followed. Then, my lord, kindly comes to the next paragraph, which is very relevant, my lord, is that paragraph, my lord, 110. Bias and the doctrine of necessity in the context of Arbitration Act. In comparison to other jurisdictions, the Arbitration Act has adopted a different approach to deal with the issue of arbitrator bias. Through the 2015 amendment, the Arbitration Act provides an extensive list of circumstances which may give rise to justifiable doubts as to the arbitrator's independence or impartiality. The enumeration of categories under 5th and 7th schedules is inspired by the orange and red list of the IBI guidelines on conflicts of interest in international arbitration. In HRD Corporation, the one, my lord, the judgment I read out just now, this court observed that the categories listed under 5th and 7th schedule must be construed by taking a broad commonsensical approach without restricting or enlarging the words. Section 12 of the Arbitration Act places a duty on a person who is approached for appointment as an arbitrator to disclose in writing any direct or indirect circumstances, such as the existence of any direct or indirect past or present relationship with any of the parties. So he falls under present, my lord. Interest in any of the parties, or interest in relation to the subject matter in dispute, whether financial, business, professional, or any kind. So professional also comes in, my lord. The disclosure of circumstances made by an arbitrator is a procedural safeguard which allows the parties to assess whether disqualification of the arbitrator is required for a case. So, my lord, the option is with the litigants once he discloses. Disclosure allows an arbitrator to overcome an appearance of bias. The parties may challenge the appointment of an arbitrator if the circumstances give rise to justifiable doubts as to their independence or impartiality. In Voestalpine, this court explained the distinction between independence and impartiality. Independence and impartiality are two different concepts. An arbitrator may be independent and yet lack impartiality, or vice versa. Well, that is exactly what I am in. Impartiality is well accepted, is more subjective concept as compared to independence. Independence, which is more an objective concept, may thus be more straightforwardly ascertained by the parties at the outset of the arbitration proceedings in the light of circumstances disclosed by the arbitrator. So post-September, my lord, the facts are such glaring that he cannot. While partiality will more likely surface during the arbitration proceeding. So, my lord, partiality will always come once appointment is done and he is in continuance of the proceeding. The fundamental premise of arbitration is the impartial resolution of disputes between parties according to the arbitration agreement, not of independence, my lord. Unlike a judge, an arbitrator is generally engaged in occupations and professions before, during, and after the arbitral proceedings. The arbitrators may also have had prior commercial or professional contracts and relationship with either of the parties to the dispute. In such circumstances, arbitration law has evolved safeguards and mechanisms to ensure the independence and impartiality of the arbitral procedure. The independence of the arbitrator is generally considered with the respect to the relationship or links between the arbitrator and one of the parties, whether financial, professional, employment, or personal. The independence of the arbitrator can be deduced objectively because the dependence arises from the relationship between an arbitrator and one of the parties, or somebody closely connected with one of the parties. In comparison, the existence of impartiality is inferred from the facts and circumstances surrounding an arbitrator's exercise of quasi-judicial functions. So, my lord, impartiality is to be looked into in 14 only. Now, my lord, kindly sees 114. An arbitrator will not be automatically disqualified in situations where the relationship of an arbitrator with parties does not fall under the categories mentioned under the 7th schedule. That is why, my lord, I say that I have come up in 14. Because, my lord, that automatic, my lord, procedure is before my lord. Yet either of the parties may have justifiable doubts about the independence or impartiality of the arbitrator. The party challenging the appointment of an arbitrator does not need to demonstrate that the arbitrator lacks independence or impartiality. It only needs to show that there are possible doubts. So, my lord, I don't need here to show, my lord, the 7th or the 5th schedule per se. I only need to show, my lord, circumstances under which there is a justifiable doubt created. That is all. My lord, I in section 14, as my lord, my learned friend was trying to point out yesterday, I don't need to show 7th or 5th schedule or 12 and 13. I need to show, my lord, that there is a justifiable doubt under the facts and circumstances, which requires the mandate to be terminated, his appointment to be terminated. And that's exactly what the Supreme Court has spelled out, my lord. If I may read once more, it only needs to show that there are possible doubts as to the arbitrator's independence or impartiality. The purpose behind incorporating the word justifiable under section 12 was to establish an objective standard for impartiality and independence. Resultantly, the possibility of doubt must be real. Well, I have placed records from the court, so and he has admitted also that these proceedings are pending, in the sense that they should be derived from the objective circumstances disclosed by an arbitrator. He also has disclosed it, Maroon. The consideration of possible doubts must be undertaken from the perspective of a fair-minded and informed person. Now, my lord, if your lordship holds from that angle, my lord, I would have, my lord, if I would have in his place, my lord, without any controversies, would have recused myself. Being a fair-minded and, my lord, an informed person, rather than the subjective views of the parties or the arbitrators. According to Gary Bond, the standard of proof adopted under Article 12 of the model law is relatively low to ensure the integrity of the arbitral tribunal and arbitral process, particularly given the extremely limited review available for substantive or procedural errors by the arbitrator. The issue of arbitrator bias is to be resolved by applying the test of real likelihood of bias in the given facts and circumstances. So, my lord, every case would be different. Every case would be different, my lord. And this is one of the rarest cases, even, my lord, I don't find any facts such glaring. Now, my lord, kindly sees 116, where section 12, my lord, has been defined. Section 12.5 automatically disqualifies any person whose relationship with the parties or counsel or subject matter of the dispute falls under any of the categories mentioned under the 7th schedule. Yes. But this is about 12.5. So, my lord, I want to show that I am not under 12.5 before, my lord. The moment I can show that there is a likelihood of doubt, my lord, that is enough for me under section 14. And, my lord, kindly sees, my lord, I read out his order, but that was not required because, my lord, that is, my lord, under 12.5. I am not in appeal before, my lord, under 12.5. My lord, under these circumstances, my lord, I would rather request, my lord, that, my lord, arbitration from the same process, from the same, my lord, period or the same place where it is still standing, my lord. I think we are in the evidence stage. A new arbitrator can be substituted, my lord, who can carry on without having any interest with any of the parties or against the parties, my lord. I think that would not prejudice any of the parties, my lord. Those are my submissions.
The admitted position is out of the 34 entries in 7 schedule, the arbitrator does not fall in any of them. That is the admitted position. I can take your lordship through the schedule. Appearing for a party.
May I just once interrupt, my lord, once? Is that, my lord, that's not an admitted situation, that's his submission. Because, my lord, I am not on 12 and 13, but if I had argued, I would have shown it is. So that's not an admitted situation.
My lord, kindly comes to the 7 schedule once. Now, the first entry is the arbitrator is an employee, consultant, advisor, or has any other past or present business relationship with the party. That's not the case. The arbitrator currently represents or advises one of the parties or an affiliate of one of the parties. Not the case. The arbitrator currently represents the lawyer or law firm acting as counsel for one of the parties. Not the case. The arbitrator is a lawyer in the same law firm which is representing one of the parties. Not the case. The arbitrator is a manager, director, or part of the management, or has a similar controlling influence in an affiliate of one of the parties if the affiliate is directly involved in the matters in dispute to the arbitration. Not the case. The arbitrator's law firm had a previous but terminated involvement in the case without the arbitrator being involved.
No, just a minute. The arbitrator currently represents the lawyer or law firm acting as counsel for one of the parties.
Not the case.
No, he's one of them.
He is appearing in a case against them.
Yes.
He is not representing any of the parties currently.
That's all right.
My lord, that situation is not covered under any of the entries in the 7th schedule. He has referred in his arguments before the arbitrator to the 5th schedule. My lord, 5th schedule, if your lordship takes entry number 20, 21 and 23. These are possibly what he may rely on in the 5th schedule. Now, my lord, the scheme of the act is, my lord, 2 schedules were made, not 1. 5th and 7th. There was a reason. But 7th was adopted from the red list of IBA. 7th is the serious relationship which incurs automatic ineligibility of an arbitrator. And the 5th schedule, my lord, was adopted from the orange list, which is a guideline, which may or may not in a circumstance lead to justifiable doubts of independence or impartiality. It's a guide. Come to the statutory provisions. So, my lord, 7th is automatic ineligibility, which does not come in this situation. It is a situation where, with reference to some entries of the 5th schedule or otherwise, there is an apprehension of bias on the part of the petitioners here. Now, my lord, the scheme of the act is, if you have
But how do you say that in the 7th schedule, none of them are getting attracted?
This, my lord, the fact that there are items which are common in 5th and 7th schedule.
Oh, that's all right. But how do you say that it's not getting attracted 7th schedule?
My lord, kindly sees the 7th schedule.
Yes.
First, my lord, heading is arbitrator's relationship with the parties or counsel. So he has a direct relationship with any of the parties or counsel.
Yes.
Now, under that, my lord, there are 14 entries.
Correct.
If he is representing one of the parties, he is disqualified.
No, not only that. The arbitrator currently represents one of the parties or an affiliate of one of the parties.
Does not. He does not represent them in any proceedings. He does not represent us in any proceedings. In some unrelated proceeding where their respondents or the counterparty, he has appeared for that party.
Yes.
This is their allegation, my lord. That is, my lord, in 5th schedule, not in the 7th schedule. This is a conscious departure by the legislature.
But one thing I must say, my lord, he has not appeared. Appeared, I did not. He is appearing in 4 matters. So there is a difference between appearing and appeared.
I am not disputing those facts. My lord, the legislature made 2 schedules. 7th was the most serious, where there is a direct link with the party. 5th is remote chances which may or may not lead to bias.
But even the arbitrator is an employee, consultant, advisor, or has any other past or present business relationship with the party.
He has not.
So he's a party.
Transacted with them. No, my lord. There is no transaction. He's not a shareholder. He's not a manager. He's not an employee of any of the parties.
He's representing them against.
Not them, my lord. He's against.
Another. Yes. Yes.
That's not a relationship with them. That's a relationship with that party, my lord. And that is why in 23, entry 23, that situation is considered, where he is representing against. That's in 5th schedule. If the legislature chose, they could have taken item 23 and put, like item 1, my lord, is common in both schedules. And my lord, they have never pleaded anything in the 7th schedule also, in their arguments there or before this court, because they are aware that 7th schedule is not attractive. Now, second is relationship of the arbitrator to the dispute. Now, the second heading, entry 15. The arbitrator has given legal advice or provided an expert opinion on the dispute to a party or an affiliate of one of the parties. The arbitrator has previous involvement in the case, but arbitrator's direct or indirect interest in the dispute. The arbitrator holds shares either directly or indirectly in one of the parties or an affiliate of one of the parties that is privately held. A close family member of the arbitrator has a significant financial interest in the outcome of the dispute. The arbitrator or a close family member of the arbitrator has a close relationship with a third party who may be liable to recourse on the part of the unsuccessful party in the dispute. So, my lord, these are the grounds which are covered in 7th schedule. But then, my lord, kindly see 14, entry 14. The arbitrator regularly advises the appointing party or an affiliate of the appointing party, and the arbitrator or his firm, his or her firm, derives a significant financial income therefrom. Not the case, my lord. Arbitrator has a significant financial interest in one of the parties or the outcome of the case. None of these, my lord. Now, my lord, in 5th schedule, you must fairly concede what may be attracted in the 5th schedule. My lord kindly takes previous services for one of the parties or other involvement in the case, entry 20 onwards in the 5th schedule. The arbitrator has within the past 3 years served as counsel for one of the parties or an affiliate of one of the parties, or has previously advised or has been consulted by the party or an affiliate of the party making the appointment in an unrelated matter, but the arbitrator, the party or the affiliate of the party have no ongoing relationship. Not this, my lord. 21. The arbitrator has within the past 3 years served as counsel against one of the parties or an affiliate of one of the parties in an unrelated case. This is the situation which is squarely attracted in this case, my lord. Now, this, my lord, consciously was left out of the 7th schedule. It was put in the 5th schedule. My lord, the difference between the 7th and 5th is, in 7th, you have automatic ineligibility. 5th schedule is a guideline. It may or may not be lead to circumstances of bias. Now, the mechanism for adjudication of these two schedules are completely distinct in the Act. Under section 12 and 13, if, my lord, there is a justifiable doubt under the 5th schedule or any other grounds which are not covered under 7th schedule, there is a challenge procedure. You have to challenge before the arbitrator. That is provided in section 13. And that challenge, my lord, has to be made within 15 days of coming to know of those circumstances. If you are not making the challenge within those 15 days, the consequences, my lord, are provided in section 4
Yes.
of the Act. My lord, kindly see section 4 of the Act. Waiver of right to object. A party who knows that any provision of this part from which the parties may derogate or any requirement under the arbitration agreement has not been complied with and yet proceeds with the arbitration without stating his objection to such non-compliance without undue delay, or if a time limit is provided for stating the objection, within that period of time shall be deemed to have waived the right to so object. Well, now kindly reads section 4 in light of the provisions of section 13(2). Failing any agreement referred to in subsection 1, party who intends to challenge an arbitrator shall, within 15 days after becoming aware of the constitution of the arbitral tribunal or after becoming aware of any circumstances referred to in subsection 3 of section 12, send a written statement of reasons for the challenge to the arbitral tribunal. So there is, my lord, a 15-day limitation period. If you become aware of a circumstance which raises justifiable doubts as to the independence or or impartiality of the arbitrator, you have to challenge within 15 days or you're deemed to waive it under section 4. Now, my lord, in light of this, kindly seize their conduct once. My lord, kindly comes to the minutes of the first meeting, which is at page 19 of the petition. Second paragraph of the minutes.
Yes.
At present, I do not have any engagement in any matter of Srei Equipment Finance Limited or its sister concerns and or subsidiary. In a matter in connection with the resolution plan of Deccan Chronicle Limited, I am engaged by a nominee director on the board of one of the subsidiary companies of Srei Equipment Finance Limited. I am presently engaged by SMS Limited in an arbitration against Srei Equipment Finance Limited. My lord, kindly see the SMS Limited, it discloses I am acting as a counsel against.
Yes.
Apart from these present engagements, I do not have any engagement either on behalf of Srei Equipment Finance Limited or against Srei Equipment Finance Limited. Now, my lord, kindly comes to para 4
Yes.
of the same, my lord, page. At the outset, the counsel appearing on behalf of the parties have indicated that they do not have any objection of my account. So they expressly waived their objection, my lord. To this.
Yes.
Now, my lord, comes to the orders which he is relying on. They are starting at page 43.
Page
This
43.
43.
Yes.
But this is dated 9th May 2024. Page 43.
Yes.
My lord, here the learned arbitrator has appeared. They have also appeared. It's not an ex parte order. They are aware on 9th May 2024 that in this proceeding, the learned arbitrator is appearing. There is no challenge. Then, my lord, next order is 17th May 2024. This is, my lord, same party. Again, my lord, their counsels have, my lord, appearance is noted. So many counsels have appeared on behalf, but they have not challenged. Next order is 9th May 2024 at page 45. Same thing, my lord. Both parties are represented. They are aware. No challenge. Then, my lord, next order, 17th May 2024. Again, my lord, same thing, same party, no challenge.
Yes.
Then, my lord, page 47. This is, my lord, possibly an appeal from those proceedings or, my lord, connected proceedings with the same party. Again, my lord, they are represented by their counsel. No challenge. 7th February 2025. Then, my lord, next page, 19th August 2024. This is, my lord, page 48. But same thing. So entire year they are aware.
Yes.
They have not made any challenge. Then, my lord, kindly comes to page 50 and kindly sees their conduct. This is Srei Equipment Finance versus SMS Limited. They had already disclosed that I am appearing for SMS Limited. And they have, my lord, annexed this order. And this is 11 July 2021. And they have raised the challenge in 2025. My lord, then next order is, my lord, page 51 against that same party which is already disclosed. That is, my lord, 26 July 2023. No challenge. My lord, next order, page 53, 27 July 2023. Same party which is already disclosed. No challenge. Then next, page 59. Same party, 22nd February 2023. Page 60, my lord, another party, 13th January 2025. Even then, no challenge within 15 days. Now, my lord, kindly comes to page 19.
Yes.
But this is the disclosure which was made.
Page?
This is page 19 of the application. Sorry, my lord, this
No,
is the
no.
first minute.
Yes, that's the first minute. Disclosure is page
Yes.
22.
Yes. Page 22. My lord, kindly takes the disclosure once
Yes.
Why this disclosure is made? I
On-
was appointed as an arbitrator by an order dated 22nd February 2022, wherein the parties consented to such appointment and also undertook not to raise any objections to such appointment by the Honorable Court. Now, my lord, at the sitting held on 20th December, kindly note,
Yes, yes.
2024, the advocate on behalf of SREI raised a concern that their clients may not be comfortable in proceeding with the arbitration before me as the arbitrator, inasmuch as I have been engaged as a counsel in a proceeding against SREI before the Honorable High Court at Calcutta. So even on 20th December 2024, they were aware they did not file any application within 15 days. They waited that you give me a formal disclosure, then I'll take my remedy of under that. Now, my lord, kindly comes back to section 13 once. Once you have challenged, what is the consequence?
Award.
Award. Wait till the award. Do not derail the proceedings. Wait till the award. You can raise all these objections when you challenge the award. And then, my lord, 14 is a separate code. 14 is only applicable to section 12.5. Now, kindly take section 12.5 once. Notwithstanding any prior agreement to the contrary, any person whose relationship with the parties or counsel or the subject matter of the dispute falls under any of the categories specified in the 7th schedule shall be ineligible to be appointed as an arbitrator. So here the concept of ineligibility. If you are in 7th schedule, you are ineligible, notwithstanding anything in the agreement. And then, my lord, proviso is also important. Provided that parties may, subsequent to disputes having arisen between them, waive the applicability of this subsection by an express agreement in writing. This has to be contrasted with section 4. So when it comes to 5th schedule, I can waive by conduct. Within 15 days, if I don't file, it's waived. But 7th schedule is so serious, I cannot waive it without a written waiver. And that is the case which then can be adjudicated directly by the court without going to the arbitrator. There is no challenge procedure under section 12.5. And well, this is the settled position. I'll show a few judgments which have been quoted with approval in the judgment cited by my learned friend. Now, the first judgment is reported in 2018 12 SCC 471. This is my lord, HRD Corporation versus GAIL.
The HRD talks about de jure also.
De
Section
jure,
14.
if it
That
comes
is a
under
distinction which
7th schedule. This is the distinction HRD makes. My lord, kindly takes. Kindly takes para 12 onwards. This distinction between 5th and 7th schedule is brought out. And para 12. Under section 12, it is clear that when a person is approached in connection with his possible appointment as an arbitrator,
is para 11.
Para 11, my lord, he has to make a disclosure in writing in which he must state the existence of any direct or indirect present or past relationship or interest in any of the parties or in relation to the subject matter in dispute, which is likely to give rise to justifiable doubts as to his independence or impartiality. He is also to disclose whether he can devote sufficient time to the arbitration, in particular to be able to complete the entire arbitration within a period of 12 months. Such disclosure is to be made in a form specified in the 6th schedule, grounds stated in the 5th schedule being a guide in determining whether such circumstances exist. Unlike the scheme contained in the IBA guidelines, where there is a non-waivable red list, parties may, subsequent to disputes having arisen between them, waive the applicability of the items contained in the 7th schedule by an express agreement in writing. The 5th, 6th, and 6th schedules are important for determination of the present disputes and are set out with the corresponding provisions of the IBA guidelines here under. So, if my lord compared, I am not taking your lordship, kindly comes to para 12. This is very important. After the 2016 Amendment Act, a dichotomy is made by the Act between parties who become ineligible to be appointed as arbitrator and persons about whom justifiable doubts exist as to their independence or impartiality. There is a dichotomy. Since ineligibility goes to the root of the appointment, section 12.5 read with the 7th schedule makes it clear that if the arbitrator falls in any one of the categories specified in the 7th schedule, he becomes ineligible to act as an arbitrator. Once he becomes ineligible, it is clear that under section 14(1)(a), he then becomes de jure unable to perform his functions, inasmuch as in law he is regarded as ineligible. In order to determine whether an arbitrator is de jure unable to perform his functions, it is not necessary to go to the arbitral tribunal under section 13. Since such a person would lack inherent jurisdiction to proceed any further, an application may be filed under section 14(2) to the court to decide on the termination of his or her mandate on this ground. As opposed to this, my lord kindly takes, as opposed to this, in a challenge where grounds stated in the 5th schedule are disclosed, which give rise to justifiable doubts as to the arbitrator's independence or impartiality, such doubts as to independence or impartiality have to be determined as a matter of fact in the facts of the particular challenge by the arbitral tribunal under section 13. If a challenge is not successful and the arbitral tribunal decides that there are no justifiable doubts as to the independence or impartiality of the arbitrator or arbitrators, the tribunal must then continue the arbitral proceedings under section 13(4) and make an award. It is only after such award is made that the party challenging the arbitrator's appointment on grounds contained in the 5th schedule may make an application for setting aside the arbitral award in accordance with section 34 on the aforesaid grounds. It is clear, therefore, that any challenge contained in the 5th schedule against the appointment of Justice Doabia and Justice Lahoti cannot be gone into at this stage, but will be gone into only after the arbitral tribunal has given an award. Therefore, we express no opinion on items contained in the 5th schedule under which the appellant may challenge the appointment of either arbitrator. They will be free to do so only after an award is rendered by the tribunal. Clear distinction is drawn between the two, my lord, 7th and 5th schedule. This is again reiterated in the judgment of the Honorable Supreme Court in Bharat Broadband versus United Telecoms, 2019, 5 SCC 755. My lord kindly takes from para 14 onwards. Yes. From a conspectus of the above decisions, it is clear that section 12(1), as substituted by the Arbitration and Conciliation Amendment Act 2015, makes it clear that when a person is approached in connection with his possible appointment as an arbitrator, it is his duty to disclose in writing any circumstances which are likely to give rise to justifiable doubts as to his independence or impartiality. The disclosure is to be made in the form specified in the 6th schedule, and the grounds stated in the 5th schedule are to serve as a guide in determining whether circumstances exist which give rise to justifiable doubts as to the independence or impartiality of an arbitrator. Once this is done, the appointment of the arbitrator may be challenged on the ground that justifiable doubts have arisen under subsection 3 of section 12, subject to the caveat entered by subsection 4 of section 12. The challenge procedure is then set out in section 13 together with the time limit laid down in section 13(2). What is important to note is that the arbitral tribunal must first decide on the said challenge, and if it is not successful, the tribunal shall continue the proceedings and make an award. It is only post-award that the party challenging the appointment of an arbitrator may make an application for setting aside such an award in accordance with section 34 of the Act. Section 12(5), on the other hand, is a new provision which relates to the de jure inability of an arbitrator to act as such. Under this provision, any prior agreement to the contrary is wiped out by the non-obstante clause in section 12(5) the moment any person whose relationship with the parties or the counsel or the subject matter of the dispute falls under the 7th schedule. The subsection then declares that such person shall be ineligible to be appointed as arbitrator. The only way in which the ineligibility can be removed is by the proviso, which again is a special provision which states the parties may, subsequent to disputes having arisen between them, waive the applicability of section 12(5) by an express agreement in writing. What is clear, therefore, is that where under any agreement between the parties, a person falls within any of the categories set out in the 7th schedule, he is, as a matter of law, ineligible to be appointed as an arbitrator. The only way in which the ineligibility can be removed, again in law, is that parties may, after the disputes have arisen between them, waive the applicability of this subsection by an express agreement in writing. Obviously, the express agreement in writing has reference to a person who is interdicted by the 7th schedule, but who is stated by parties after disputes have arisen between them to be a person in whom they have faith, notwithstanding the fact that such person is interdicted by the 7th schedule. The Law Commission report, which has been extensively referred to in some of our judgments, makes it clear that there are certain minimum levels of independence and impartiality that should be required of the arbitral process, regardless of the parties' agreement. This being the case, the Law Commission then found the Commission has proposed the requirement of having specific disclosures by the arbitrator at the stage of his possible appointment regarding existence of any relationship or interest of any kind which is likely to give rise to justifiable doubts. The Commission has proposed the incorporation of the 4th schedule, which has drawn from the red and orange lists of the IBA guidelines on conflicts of interest in international arbitration, and which would be treated as a guide to determine whether circumstances exist which give rise to such justifiable grounds. On the other hand, in terms of the proposed section 12(5) of the Act, well, 4th schedule in the Law Commission report, now what is 5th schedule? Now, on the other hand, in terms of proposed section 12(5) of the Act and the 5th schedule, in the draft report, 5th schedule is what is now the 7th schedule. 5th schedule, which incorporates the categories from the red list of the IBA guidelines as above, the persons proposed to be appointed as an arbitrator shall be ineligible to be so appointed, notwithstanding any prior agreement to the contrary. In the event such an ineligible person is purported to be appointed as an arbitrator, he shall be deemed to be unable to perform his functions in terms of the proposed explanation to section 14. Therefore, while the disclosure is required with respect to a broader list of categories as set out in the 4th schedule and as based on the red and orange lists of the IBA guidelines, the ineligibility to be appointed as an arbitrator and the consequent de jure inability to so act follows from a smaller and more serious subset of situations as set out in the 5th schedule and as based on the red list of the IBA guidelines. So only this subset the court will then declare as ineligible and under section 14 terminate the mandate. The Commission, however, feels that real and genuine party autonomy must be respected, and in certain situations, parties should be allowed to waive even the categories of ineligibility as set out in the proposed 5th schedule. This could be in situation of family arbitration or other arbitrations where a person commands the blind faith and trust of the parties to the dispute despite the existence of objective justifiable doubts regarding his independence and impartiality. To deal with such situations, the Commission has proposed the proviso to section 12(5) where parties may, subsequent to disputes having arisen between them, waive the applicability of the proposed section 12(5) by an express agreement in writing. In all other cases, the general rule in the proposed section 12(5) must be followed. In the event the High Court is approached in connection with appointment of an arbitrator, the Commission has proposed seeking the disclosure in terms of section 12(1), and in which context the High Court or its designate is to have due regard to the contents of such disclosure in appointing the arbitrator. Thus, it will be seen that party autonomy is to be respected only in certain exceptional situations, which could be situations which arise in family arbitrations or other arbitrations where a person subjectively commands blind faith and trust of the parties to the dispute, despite the existence of objective justifiable doubts regarding his independence and impartiality. Now, my 17, my lord, is the summary, very important. Scheme of sections 12, 13, and 14, therefore, is that where an arbitrator makes a disclosure in writing which is likely to give justifiable doubts as to his independence or impartiality, the appointment of such arbitrator may be challenged under sections 12(1) to 12(4), read with section 13. However, where such person becomes ineligible to be appointed as an arbitrator, there is no question of challenge to such arbitrator before such arbitrator. In such a case, that is, everything which falls under section 12(5). Section 14(1)(a) of the Act gets attracted inasmuch as the arbitrator becomes, as a matter of law, that is de jure, unable to perform his functions under section 12(5), being ineligible to be appointed as an arbitrator. This being so, his mandate automatically terminates and he shall then be substituted by another arbitrator under section 14(1) itself. It is only if a controversy occurs concerning whether he has become de jure unable to perform his functions as such that a party has to apply to the court to decide on the termination of the mandate unless otherwise agreed by the parties. That in all section 12(5) cases, there is no challenge procedure to be availed of if an arbitrator continues as such, being de jure unable to perform his functions as he falls within any of the categories mentioned in section 12(5) read with the 7th schedule. A party may apply to the court, which will then decide whether his mandate has terminated. Questions which may typically arise under section 14 may be as to whether such person falls within any of the categories mentioned in the 7th schedule, or whether there is a waiver as provided in the proviso to section 12(5) of the Act. As a matter of law, it is important to note that the proviso to section 12(5) must be contrasted with section 4 of the Act. Section 4 deals with cases of deemed waiver by conduct, whereas the proviso to section 12(5) deals with waiver by express agreement in writing between the parties only if made subsequent to disputes having arisen between them. Now, my lord, similar situations have arisen, my lord. I'm citing a judgment of the Delhi High Court, where on the grounds on the 5th schedule and justifiable doubts of impartiality, the party has approached the court under section 14. My lord, kindly takes paragraph 14 of this judgment, Justice Vibhu Bhaklu's judgment, 2022 SCC Online, Delhi 900 copy.
That's different. I don't know. I have it. That's it.
Which one? No, not Reliance. My lord has just K-ROM Advanced Technologies versus NEC Technologies, para 14. Okay.
I've seen it.
It is well settled that a petition under section 14(1) of the NC Act cannot be filed to challenge appointment of the arbitral tribunal.
But here the facts are a little different. They have given up that challenge to, so the appointment of the arbitrator.
But the principle of law which is laid down is that if it is any ground under 12(3) read with 5th schedule, you have to go to the arbitrator. If unsuccessful, wait till the award. And only if you are under 7th schedule, and you can show that the arbitrator is per se ineligible, then you can approach the court under section 14. But another judgment where all these judgments have been recently considered by Delhi High Court. This is 2022 SCC Online, Delhi 4310. Para 26, section 12, 13 and 14 are quoted. I'm just skipping that, my lord. Para 27. Section 12(1) mandates that where a person is approached in connection with his possible appointment as an arbitrator, he shall disclose in writing any circumstances which, amongst others, are likely to give rise to justifiable doubts and apprehensions as to his independence or impartiality. In terms of subsection 3 of section 12, the jurisdiction of an arbitrator may be challenged by a party if circumstances exist and give rise to justifiable doubts as to his independence or impartiality. In terms of explanation 1, which stands...
Sorry. Where are you reading this one?
My lord, para 27.
Yes.
Section 12(1) mandates that where a person is approached in connection with his possible appointment as an arbitrator, he shall disclose in writing any circumstances which, amongst others, are likely to give rise to justifiable doubts and apprehensions as to his independence or impartiality. In terms of subsection 3 of section 12, the jurisdiction of an arbitrator may be challenged by a party if circumstances exist and give rise to justifiable doubts as to his independence or impartiality. Terms of explanation 1, which stands placed in section 12(1), grounds stated and set out in the 5th schedule are to act as a guide for determining the aforesaid. Explanation 1 is couched in mandatory terms and uses the term shall guide in determining. The challenge procedure where such an objection is taken is then specified and set out in section 13. Dealing specifically with a challenge which is referable to section 12(3) of the Act, section 13(2) stipulates that a party who intends to challenge an arbitrator shall send a written statement of reasons for challenge to the arbitral tribunal. Upon receipt of that statement, it would be open for an arbitrator to recuse or withdraw from the arbitral proceedings. However, the contingency where an arbitrator fails or refuses to withdraw is one which is duly conceived of under the Act. Section 13(3) prescribes that if the arbitrator fails to withdraw, the arbitral tribunal shall decide on the challenge. terms of section 13(4), if that challenge fails, the arbitral tribunal would be entitled in law to continue the proceedings and make an award. On a due consideration of the relevant statutory provisions which would govern the question which stands posited, the court is of the view that while sections 12, 13 and 14 of the Act, the Trinity provisions, may be recognized as constituting a composite statutory scheme dealing with the subject of challenge to an arbitrator and termination of mandate, they clearly appear to construct separate causeways for a challenge that may be laid. While sections 12 and 13 lay down the procedure of challenges which must mandatorily be mounted before the arbitral tribunal, section 14 speaks of challenges that may be instituted before a court as defined under the Act. Section 12 relates to a challenge to the jurisdiction of an arbitrator that may be based either on the 5th or the 7th schedule. Insofar as the question of justifiable doubts is concerned, the same is statutorily ordained to draw color from the provisions incorporated in the 5th schedule. The 7th schedule, on the other hand, lists out the disqualifications which are incurable and non-derogable except where parties expressly concur on a waiver. A careful reading of the 7th schedule would establish that it does not deal with the aspect of justifiable doubts relating to independence or impartiality that may arise by virtue of the conduct of an arbitrator or the manner in which proceedings may be conducted by the arbitral tribunal at all. It deals with disqualification by virtue of the arbitrator's relationship with parties, counsel, or the dispute, and extending to situations where the arbitrator may said to have a direct or indirect interest in the dispute. These non-derogable disqualifications are predetermined and decreed by law. On a conjoint reading of sections 12, 13, and 14 of the Act, the court is of the considered opinion that it is the disqualification set out in the 7th schedule alone which can be recognized as being the de jure disqualifications under the Act. De jure, as is well settled, would mean something stipulated or prescribed by law or according to law. It would thus include disqualification which would automatically render an arbitrator ineligible to be either appointed or to continue. These disqualifications would inevitably result in the termination of mandate. Bias, as distinct from the above, would be an issue which would have to axiomatically be established in fact. An allegation of bias would have to be alleged and proven. Viewed in that light, it is manifest that it would clearly fall outside the pale of a de jure disqualification. The view taken by the court stands fortified from a reading of section 12(3) of this, which mandates a party establishing that circumstances exist giving rise to a justifiable doubt with respect to the independence or impartiality of an arbitrator. The court, for the following additional reasons, finds itself unable to countenance the submission that a bias allegation would fall within the ambit of section 14(1)(a) of the Act. As has been noticed above, the subject of bias and justifiable doubt is specifically dealt with in section 12. If the court were to accord an interpretation upon sections 12 and 14 and treat such an allegation as falling within an overlap of the aforesaid provisions, it would not only be contrary to well-settled rules of interpretation, but would also clearly violate the evident scheme and intent of the legislature. A section 12(3) challenge is guided by the provisions of section 13. Subsections 4 and 5 thereof provide for the consequences which would ensue once such a challenge fails. They mandate that in such an eventuality, the proceedings before the arbitrary tribunal would have to be continued and terminate only once an award is rendered. They perceive of the party challenging the mandate of an arbitrator to await the making of an award and only then assailing the same in accordance with section 34. The provision does not contemplate a curial challenge being raised or pursued at the intermediate stage. Recognizing the right to raise such a challenge at the interim stage by recourse to section 14(1)(a) would clearly be contrary to the evident legislative intent and resolve to debar such a recourse. The expression de jure as occurring in section 14 would necessarily have to be construed as conditions which are recognized and so ordained by law. The subject of bias and justifiable doubts is clearly one which is specifically provisioned for in section 12. Once that subject stands taken note by the legislature in the said provision, it would be tenuous to hold an allegation of bias as being one which would be triable in a section 14 proceeding also. Sections 12 and 13, when read together, thus appear to constitute a complete and an independent code for the purposes of trials of such an allegation. They clearly mandate and oblige the arbitral tribunal to examine whether circumstances exist that give rise to justifiable doubts. The factual inquiry which would necessarily have to be undertaken in connection with the aforesaid clearly appears to be controlled and governed by sections 12 and 13 exclusively. Once the aforesaid issue stands governed by the aforenoted two provisions, it would be incorrect to recognize an identical inquiry being undertaken by the court under section 14. This would not only fall foul of the principles enunciated in HRD Corporation and Bharat Broadband, it would also appear to be contrary to the legislative intent enshrined in subsections 3, 4, and 5 of section 13. The aforesaid conclusions of the court would also be in consonance with the decisions of the Supreme Court, which were commended for the consideration of the court by Mr. Salvi. The Supreme Court in HRD Corporation observed that once an arbitrator becomes ineligible by falling in any one of the categories specified in the 7th schedule, he would in turn be liable to be viewed as having become de jure, unable to perform his functions. This, since in law section 12.5 and the 7th schedule, he is to be regarded as ineligible. HRD Corporation goes on to explain that once an arbitrator suffers ineligibility in terms of section 12.5, read with the 7th schedule, it would clearly lack the inherent jurisdiction to proceed any further. And in such a situation, his mandate would be liable to be terminated in accordance with section 14 of the Act. The Supreme Court in HRD Corporation further went on to pertinently observe that where a challenge beyond a ground set out in the 5th schedule and relate to justifiable doubts with respect to the arbitrator's independence or impartiality, those issues would have to be determined in accordance with the challenge procedure set out in section 13. It is this dichotomy between the challenges which may be raised on the basis of the 5th and 7th schedule which were highlighted and underlined in HRD Corporation. The court notes that the Supreme Court in the aforesaid decision went on to further hold that where a challenge based on the grounds of independence or impartiality fails, the tribunal must then continue the arbitral proceedings under section 13.4 and make an award. It is only after such award is made that the party challenging the arbitrator's appointment on grounds contained in the 5th schedule may make an appointment for setting aside the arbitral award in accordance with section 34 on the aforesaid grounds. HRD Corporation is thus an incontestable authority for the proposition that challenges which may be raised with respect to justifiable cause relating to impartiality or independence would have to necessarily follow the route prescribed by sections 12 and 13 of the Act. The aforesaid authority also exposits the legal position that a disqualification with which an arbitrator may be visited and which would fall within the ambit of the grounds set out in the 7th schedule would have to be considered exclusively by the court as defined under the Act and under section 14. The aforesaid view as expressed in HRD Corporation finds resonance in the principles enunciated in Bharat Broadband. In the aforesaid decision too, a clear distinction was recognized to exist between an ineligibility which may be incurred by virtue of section 12.5 of the Act, read with the 7th schedule, and the issue of a justifiable doubt as to the independence or impartiality of an arbitrator. The de jure disqualification thus clearly appears to have been recognized to be one which would be relatable to section 12.5 and the 7th schedule alone. But after this, all the judgments of the Honorable Delhi High Court on this point has been considered from paras 46 to 49. And I'll just 46 to 45. Well, I'll just place para 46 to show one of the arguments that was taken is why send us back to the same arbitrator who we are uncomfortable with in proceeding. That argument was also dealt with much. Para 46. The court also finds itself unable to sustain the submission of Mr. Ganguly that compelling a party to proceed in the arbitration, even though it may have lost faith in its members, would not only be a useless formality, but also cause grave prejudice for the following reasons. It may at outset be noted that the provisions of the Act leave no space of ambiguity with respect to the procedure to be adopted once a challenge on the ground of bias fails before the arbitral tribunal. In fact, and to the contrary, the Act unequivocally commands the parties to proceed further till such time as an award is made. The right to challenge a ruling by the arbitral tribunal on the question of justifiable doubt thus stands statutorily deferred till such time as the award is rendered. The court draws sustenance for the aforesaid conclusion also from the explicit enunciation of the legal position by the division bench of the court in Progressive Career Academy. Court is thus of a firm opinion that it would be wholly impermissible for it to either create or countenance such a right by interpreting section 14(1)(a) in the manner as suggested by the petitioner. The fact that the arbitral tribunal stands statutorily empowered to deal with such a challenge also does not appear to be an incongruous or incompatible facet when one bears in mind the principles of competence, which informs section 16 of the Act. In fact, the power of the arbitral tribunal to rule on its own jurisdiction constitutes a keystone of the Act and the UNCITRAL model law on international commercial arbitration provisions which have been adopted. The court fails to find any merit in the submission of Mr. Ganguly that the members of the arbitral tribunal have already prejudged the entire issue and that relegating the petitioner to pursue the pending, there the application was pending. So, my lord, they were relegated to go back to the tribunal and raise their challenge to the independence and impartiality. My lord, so far as the judgment that has been cited, my lord is well aware this is the larger bench which was constituted following the judgment in Central Organization for Railway Electrification, where there was a difference in opinion with the judgment in Perkins. So this is dealing with an unilateral appointment of an arbitrator by one party. And my lord, in fact, these paragraphs which I have cited from Bharat Broadband and from HRD Committee are quoted in this judgment. It is dealing with the 7th schedule, ineligibility under 7th schedule, where the party itself is appointing the arbitrator. There's no applicability to the facts of the instant case. Great.
Yes, Mr. Banerjee, it seems like all the judgments are only indicating one thing, that to attract 14(1)(a), you need to fall under the 7th schedule.
And I fall, my lord. I am so thankful to my learned friend for arguing, as if, my lord, we were arguing an appeal from 12 and 13. He has helped me out, and I'll show from his judgment itself, my lord.
Then all you need to do is show that how.
Yes,
7th schedule is
absolutely,
applied.
absolutely, my lord. I understand. Now, my lord, kindly sees, before that, two things I must show. My lord, although lordship is not hearing appeal under 12 and 13 in a 34, but what he said is incorrect and what he did not read out is that, my lord, kindly take section 12 once. Even if lordship was hearing a 34, he was incorrect in his statements from the act itself. Kindly takes, my lord, 12 once. 12.2, section 12.2. An arbitrator from time of his appointment and throughout the arbitral proceedings shall without delay disclose to the parties in writing any circumstances referred to subsection 1 unless they have already been informed of them by him. So, my lord, it is not that he will inform once, but he will inform and disclose throughout. And that's exactly the case what my lord is seen, what he has not done. Firstly, apropos this, my lord, comes 13.2, where, my lord, upon or after becoming aware of any circumstances referred to in subsection 3 of section 12, send a written statement of reasons for challenge. So therefore, my lord, I am supposed to challenge once he discloses. And my lord, I showed the dates, my lord. He disclosed on 8th of February, admittedly on 2025. My challenge, my lord, on written form was filed on 13th of February 2025. So even if I was in a 34, my lord, it's not a case that I have gone contrary to the law. I have challenged post his disclosure. This he did not read out. Then, my lord, comes to, my lord, that this is not a challenge, my lord, to, my lord, the arbitral order which has been passed. I just showed the order to show, my lord, his conduct. Now, my lord, kindly comes to 7th schedule. So the legislative intent, my lord, cannot be on a case-to-case basis because the legislature, my lord, never, my lord, thinks of the facts of the case. It is not possible, my lord, when the drafting of the statute is made. My lord, kindly comes to the 7th schedule once and kindly takes, my lord,
Yes.
kindly takes, my lord, first the 5th schedule.
5th, there's no issue.
No, I'll show first 5th, my lord, then I'll show. Kindly takes the 5th schedule itself, 30. The arbitrator's law firm is currently acting adverse to one of the parties or an affiliate of one of the parties. Therefore, my lord, the concept of law firm is there everywhere. In Calcutta, we do not have, we have a counsel and a, my lord, advocate on record practice. So, my lord, if the arbitrator is acting currently adverse to one of the parties, in this case it is, he is, my lord, definitely not eligible under 30, my lord, 5th schedule. Now, my lord, kindly sees apropos this, my lord, kindly comes to my lord 19. Straight away to 19.
19 of
19 of my lord 7
7.
schedule.
Yes.
The arbitrator or a close family member of the arbitrator, we are not on that, has a close relationship with a third party who may be liable to recourse on the part of an unsuccessful party in dispute. Therefore, my lord, here, all right, 19 squarely falls because he has, my lord, a relation as a counsel to a third party who may be liable to recourse on the part of an unsuccessful. He is acting as an, my lord, counsel for a third party against me in all these 4 proceedings. Because I can go further, I can say, my lord, is professionally involved, because, my lord, 7 says about non-involvement as a professional also. But I, my lord, go further to show that he is involved with a third party against me in all these 4 proceedings, which is evident from the records. And that makes him ineligible. The entire, my lord, submissions was on an appeal as if on 12-13, all the judgments I'll show. And all the judgments show, my lord, once he does that, he squarely falls under section 14. He will not have a third party interest against one of the parties before him. He is acting for a third party. Now, my lord, whoever is the respondent here is not a party to the arbitration proceeding, admittedly. And, my lord, he is acting for that party against me in a proceeding before the court in all four matters. So, my lord, I squarely fall not only under 530, but I squarely fall also under 7th schedule clause 19, because he is acting for a third party adverse to, my lord, or a recourse against me, which he cannot. And now, my lord, apropos this, kindly read 15 and 16. The arbitrator has given legal advice or provided an expert opinion on the dispute to a party or an affiliate of one of the party.
19 doesn't attract.
Sorry, my lord.
19 doesn't attract.
But he is acting for a third party.
No, that's not how it reads.
Kindly sees, my lord, the arbitrator has a
has
close relationship with a third
who
party.
may be liable to recourse on the part of the unsuccessful party in the dispute.
Yes.
It's a dispute which they're talking about, and it is a present dispute. There's nothing like that. It doesn't read that.
But he cannot act with a third party. Now, my lord, kindly takes,
Dispute
my
is
lord.
not acting with the third party in the present dispute.
Now, my lord, kindly takes, my lord, 15 and 16 also. Kindly sees, my lord, the arbitrator has given legal advice. My lord, legal advice, after that there is an or.
On the dispute. It's talking about that particular dispute.
No, my lord, he is given.
It's not talking about any other dispute. The arbitrator has given legal advice.
Yes.
Provided an
No, my lord, I am not on that. Kindly, my lord, that is why I said
to a party.
the arbitrator has given legal advice on the dispute to a party or an affiliate of one of the parties.
He has not given any.
And, my lord, kindly comes to 16. The arbitrator has previous involvement in the case. Now, my lord, can it be, my lord, visualized that, my lord, an arbitrator?
These are all confined to disputes between the parties.
Yes, but, my lord, an arbitrator, my lord, cannot in any manner act at the same time.
5th schedule. 7th schedule, you show me.
5th schedule, my lord. 5th schedule, my lord, 30 squarely falls. 30 squarely falls.
Agreed.
Now, my lord, kindly sees, my lord.
21.
Yes. 21 also. 21 also, but 30, my lord, I think it's the closest. 30 is the closest. I wouldn't say.
7th schedule, nothing is there.
My lord, kindly takes, my lord. My lord, kindly takes, my lord, gives me one moment, my lord. Affiliation of party.
Both your 19, 15, you can't lose sight of the heading. These are all related only.
No, I am not, my lord. I am not at all, my lord. I am saying, my lord.
Particularly related to the dispute.
I am saying, my lord. I am saying, my lord, kindly come to 2. Kindly comes to 2. Wait,
Two is the one which I pointed out, but it's not there. They are not advising any one of the parties. He's
I am
asking
saying, my lord,
you.
I am saying, my lord, as far as biasness is concerned, my lord, biasness, my lord, is not restricted only to, my lord, section 12 and 13. Biasness also, my lord, as I read out from the last judgment, my lord, it is on the facts and circumstances of the case.
No, but how do we overcome the decisions which are there, which confines it or limits it, or the distinction which has been given between 13 and 14 is to the extent that if something falls within the 7th schedule, then 14 gets attracted. If it doesn't, then 14 is not attracted.
My lord, that is not the thing. My lord, what it says, I'll show the paragraphs also. It says that, my lord, if it is under the 7th schedule, automatically 14 gets attracted.
Correct.
Automatically, the word. But, my lord, it
Not
does.
automatically. It gets only attracted. That's where the distinction they are trying to make out. That unless until then the challenge is under 13, then you wait for the award and then you challenge in 34. That's what they say.
That is, my lord, under 12 and 13.
If you are invoking 14, then it has to fall within one of the categories of the 7th schedule, then 14 gets invoked.
My lord, it does not say, that's exactly what I'll show. It does not say, my lord, that, my lord, it is only, the criteria is only that, my lord, 14 has to fall under 7 schedules, then only 14 will come. Because, my lord, kindly sees, my lord, otherwise the provision of de jure and de facto wouldn't have been there. It would have been de facto only, because the facts would only reveal whether he has got, my lord, an affiliation or not. And the judgments also does not say, I'll show, my lord, it shows that if I fall on the 7th schedule, lordship does not have to look anywhere. But, my lord,
Then I don't have
admit
to
my
look at it.
section 14.
Correct.
Now, my lord, that is why I say, my lord, it is de jure and de facto, because, my lord, if I do not fall under 7th schedule, but I can show, my lord, from the facts of the case that, my lord, there are justifiable doubts which are, my lord, created, then, my lord, lordship still has jurisdiction. That's exactly what the wording, my lord, is the judgments also. And, my lord, the judgments which he has read out also. I'll show that also, my lord. Now, my lord, kindly comes to the judgments that he has relied upon. My lord, kindly takes this particular judgment and kindly sees the facts also.
Which one?
2022 SCC Online Delhi 910. I think this lordship already has NEC Technologies, my lord. Justice.
No, I had Justice Bakru's judgment.
Yeah, that is exactly, my lord. This is Justice Bhakru's judgment only, my lord.
Yes.
My lord, kindly sees the facts of the case which lordship already, my lord, had pointed out. That they are completely different.
That's different.
Absolutely different, my lord.
This one is different.
This is
This is
absolutely
only
different
to the
facts.
extent what he's trying to show as far as 14 is concerned. Paragraph 14 is just trying to show the legal position as far as
Yes.
13
yes,
and 14 are
yes.
concerned.
This is not, my lord, a
Only to
precedent,
impress
my lord, on the issue before, my lord.
No, not.
And there is no quarrel with this, my lord. I am not saying at all that, my lord,
That
this.
he also agreed,
So
as
this
far as
precedent, my lord, is not on the facts of the case.
not this, but what
My
about
lord, kindly then, my lord, takes the other
Union
judgments.
of India versus
Yes,
Reliance
my lord,
Industries,
kindly comes to that judgment
Bharat
itself.
Broadband?
My lord, kindly comes to this judgment, Union of India versus Reliance Industries. Kindly
HRD?
comes to that. Kindly comes to that.
You have to
Kindly
put
comes.
these three judgments: HRD.
Yes, my lord.
Union-
He has shown HRD, Bharat Broadband,
Yes.
and Reliance Industries. Now, kindly
I
comes
think
to
HRD
Reliance.
was the first one, if I'm not wrong,
Yes,
right?
first.
So it started with HRD. So let us see HRD first.
Yes, my lord. Kindly takes HRD first. Now, my lord, in HRD, my lord, kindly comes to the relevant portion, my lord.
Yes.
Kindly comes to page 488. Before 488, I think he read 11.
He read 11.
Kindly comes to 11. My lord,
Yes.
11 is all about section 12.
Yes.
I have no quarrel because I am not under appeal
No,
before my
just
lord.
to give
Just
a
to show what is the powers under section 12.
Yes.
Now, my lord, kindly comes to straight away page 488, paragraph 12. After the 2016 Amendment Act, a dichotomy is made by the Act between persons who become ineligible to be appointed as arbitrator and persons about whom justifiable doubts exist as to their independence or impartiality. Since ineligibility goes to the root of the appointment, section 12.5 read with the 7th schedule makes it clear that if the arbitrator falls in one of the categories specified in 7th schedule, he becomes ineligible to act as an arbitrator. Once he becomes ineligible, it is clear that section 14(1)(a), he then becomes de jure.
That's
I want to mark here, my lord. He
Yes.
then becomes de jure unable. My
Yes.
lord, de facto part is not dealt with.
So-
I am on that, my lord. I'll show that, my lord. De jure unable to perform his
Factor will
functions.
not be attracted also. Mr.
It will be, my lord. That is why, my lord,
All right, sure.
14 says,
I'm not stopping. I'm just
sir,
saying.
this is a little
This is very interesting.
very interesting case. I must say, because my lord, facts are such. I'm sure both of us, my lord, will try to assist, my lord. A very interesting case. Now, my lord, kindly sees this judgment. When he was reading, I marked it.
Yes.
He then becomes de jure unable to perform his functions, in as much as in law he is regarded as ineligible. So, my lord, if I can show under 7th schedule, straight away lordship will, my lord, will not look into anything.
Correct.
Admit.
Correct.
Now, my lord, in de facto, that's also a part of section 14. My lord, if de facto I can show, my lord, which Supreme Court, my lord,
Let's see that.
my lord, the biasness paragraphs were there. If I can show in de facto part, then that would be on the facts of that case.
Let's see that.
Now, my lord, kindly sees to perform. In order to determine whether an arbitrator is de jure unable to perform his functions, it is not necessary to go to the arbitral tribunal under section 13. Since such a person would lack inherent jurisdiction to proceed any further, an application may be filed under section 14(2) of the code to decide on the termination of his or her mandate on this ground. My lord, I stop here once. De facto part will never come, my lord, at the instance of the appointment. De facto part under section 14 will only come during the course of arbitration. My lord, this is a very thin distinction, but a very, my lord, important distinction in
But
14.
you see, if similar arguments had been advanced as far as this, which is Union of India versus Reliance is concerned before
Yes.
Justice Verma. Now he had dealt with that during the course of the proceedings. The concerned counsel felt that the outcome would be
No, I am not on that, my lord. I am not on the outcome. Please, my lord,
not only
forget.
the outcome.
No,
He feels that the biasness and the impartiality is compromised.
yes, but my lord, I am not on the outcome part.
Let's forget the outcome.
Yes.
I've wrongly stated the outcome. I'm saying, I jumped the gun.
No, I submitted, but
you
that, my lord, that submission is perhaps not
He is
something
basically
acceptable.
saying that impartiality is something which is doubtful and questionable,
Yes.
and the biasness is there,
Yes.
which is writ large. It can be seen that. But even in a situation like that, the court has held that no, you follow the proper channel as far as 13 is concerned. Let the award be published. You challenge it.
Perhaps not. I'll read that judgment, the next paragraph, which I'll show, my lord. But now, my lord, as I said here, kindly sees, my lord, here de facto is not dealt with. My lord, importantly, why it has not been dealt with is that de facto will only appear during the course of arbitration. The court, at the inception of, my lord, the ineligibility criteria under de jure, at the time of appointment, cannot, my lord, conceive of a situation which will appear in the future like this. So, my lord, de facto is not dealt with here.
No.
And that, my lord, is another facet of section 14 that lordship has to, my lord. That's part of the.
Show me some judgments on de facto.
Yeah.
If you want to evolve that law.
Yes, I have to, because, my lord,
because
now
that's what you're trying to evolve.
Absolutely, my
And
lord.
this is something which you have just thought on your.
Because I have to, my lord. No, it is, my lord. We always.
Mr. Banerjee, I'm not saying it's a good.
I have to, my lord, because after reading these judgments,
Yes,
I have to. That is why I marked it.
Sure.
I marked it, my lord. So, my lord, as I say, my lord, if it would be de jure, straight away, lordship will admit under 14(2). I fall under the 7th schedule. If I do not, my lord, then comes the factor of de facto. Now, my lord, kindly sees in this, there is no discussion of de facto at all. No discussion. The law has been well laid down, my lord, with regard to de jure. Kindly sees, my lord, as opposed to this, in a challenge where the grounds stated in the 5th schedule are disclosed, which give rise to justifiable doubts as to the arbitrator's independence or impartiality, such doubts as to the impartial and impartial.
This clarity is there.
Yes, 12 and 13. Now, my lord, kindly sees apropos this, the next paragraph which is relevant, my lord,
Yes.
which I just saw, is that, my lord, the entirety of this judgment
Yes.
resolves around the de jure factor. And, my
Yes.
lord, ultimately, my lord, what is the finding? Kindly sees, my lord, paragraph 31.
Yes.
It was then argued that under explanation 3 to the 7 schedule, maritime or commodities arbitration may draw arbitrators from a small specialized pool, in which case it is the custom and practice for parties to appoint the same arbitrator in different cases. This is in contrast to an arbitrator in other cases where he should not be appointed more than once. We are afraid that this argument again cannot be countenanced for the simple reason that explanation 3 stands by itself and has to be applied as a relevant fact to be taken into account. It has no indirect bearing on any of the other items mentioned in the 7th schedule. Again, my lord, the court has proceeded on the de jure factor. And, my lord, drawn a distinction between, my lord, 12.13 and 14.2. My lord, that is an easy path. Now, my lord, kindly takes the next judgment, my lord, which is, my lord, Reliance. Before I, my lord, show Bharat Broadband. In Reliance, my lord, kindly takes paragraph 3 first. Very important. The facts. The allegation in the present petition essentially is that the procedural orders passed by the arbitral tribunal and the manner in which proceedings have been conducted clearly leads the petitioner to apprehend an evident bias and harboring justifiable doubts as to the independence and impartiality of the arbitrator. The petitioner alleges that the various procedural orders passed by the tribunal would indicate that it has treated them unfairly, denied them unreasonable opportunity, and of favoring the case of respondents numbers 1 to 3. Squarely, my lord, the facts does not fall under either 7 or 5. Squarely, because these are, my lord, I may be aggrieved by an order.
So that is why I was giving a counter argument to you to the extent that these are during the course of the proceeding.
Yes. Now, my lord, during
You
the
are saying that you are distinguishing the other judgments on the fact that during the course of the proceedings, none of these judgments will be applicable. But here, it is during the proceedings where it is being pointed out that there's a biasness and partiality which is there. So it is during something similar to your facts.
but my lord, I will show it.
And let's see then what is
Yes,
the...
I'll read paragraph 4 also, my lord. That is why, my lord, I wanted to show the facts. My lord, here kindly sees, my lord, during the course of proceedings, correct. But what he complains of at the later stage is on the facts of, my lord, the schedule. That is exactly I want to draw the distinction. Now, my lord, kindly sees, however, and before the court proceeds to elaborate upon the submissions which were addressed in support of the present petition by Mr. Ganguly, it would be pertinent to consider the rule upon a preliminary objection which was raised by Mr. Salve, appearing for respondent number such and such with respect to the maintainability of the petitioner itself, because the maintainability point was raised. Taking the court through the relevant statutory provision, Mr. Salve submitted that in terms of section 12 of the Act, an arbitrator is obliged to make a disclosure with respect to the existence of any relationship or interest that he may have with any of the parties, my lord, kindly sees, or in relation to the subject matter of the dispute, and which is likely to give rise to justifiable doubts as to their independence or impartiality. Then, my lord, kindly comes to paragraph 7. Mr. Salve then submitted that subsection 5 of section 12, which came to be introduced by virtue of the Arbitration and Conciliation Amendment Act 2016, creates an ineligibility criterion on grounds set out in the 7th schedule to the Act, and which would operate notwithstanding any prior agreement to the contrary between the parties. Mr. Salve further clarified that the aforesaid is subject to the solitary exception of a situation where parties may waive the applicability of subsection 5 by way of an express agreement in writing. So, Mala, this is all on 12.5 and 7 schedule. According to Mr. Salve, 12.5 read with the 7 schedule constructs a non-derogable disqualification. An arbitrator accused of being affected by the aforesaid provisions would become de jure unable to perform his functions. So, my lord, the submissions are again on de jure factor. Then, my lord, kindly comes to paragraph 9. Mr. Salve further contended that a challenge to an arbitrator on the grounds enumerated in 12.3 would have to necessarily follow and abide by the procedure set out in section 13. Learned Senior Counsel submitted that the terms of subsections 3, 4, 5 of section 13, once a challenge to an arbitrator is raised in terms of 12.3, then the arbitrator fails to withdraw from office, the arbitral tribunal would have to necessarily rule upon the challenge. It was further pointed out that in terms of 13.4, if a challenge is laid down in accordance with the procedure notice above fails, the arbitral tribunal is mandatorily obliged to continue the arbitral proceedings and render an award. And then the challenge under 34. This is all under the 5th schedule that the discussions on. Now, my lord, kindly comes to next, the relevant paragraph where, my lord, the distinction can be drawn. Kindly comes to, my lord, page, my lord, 16.
Yes.
Now, kindly comes to, my lord, paragraph 24. Mr. Ganguly laid stress upon the following observations as appeared in the aforenoted communication in order to buttress the aforesaid contention. The respondent's application concludes with its submission that mandate of the majority of the tribunal stands terminated in accordance with section 14 by reason of the facts and circumstances set out in the application. The claimant's contention is that the application is misconceived and without effect. I should state that Sir Bernard and I do not accept the respondent's allegation that we are explicitly biased or lack independence and impartiality in any way. By the tribunal's communication dated 29th November 2022, in conformity with successive procedural orders and correspondence appointing and fixing 10:30 a.m. to on Monday, 5th December 2022 at such and such as the time and date and the venue of the commencement of final hearing on the merits of this arbitration, the tribunal referred to that hearing and the necessary preparations for it. That date and time remain unchanged. They have not been altered by any order of the tribunal or any other lawful order. Accordingly, it remains at the present the duty of all concerned, including the parties and their advocates, to attend the fulfillment of their respective obligations to the arbitration and to any additional orders that the tribunal may make. Now, my lord, this is on the facts of this case. The challenge is on the facts of this case, not, my lord, the similar to what we have. Then 12 and 13 is quoted. Now, my lord, kindly comes to paragraph 32 straight away. Straight away to paragraph 32, my lord. On a conjoint reading, Lordship, is that paragraph? On a conjoint reading of sections 12, 13 and 14 of the Act, the court is of the considered opinion that it is the disqualification set out in the 7th schedule alone. Finally, mark, my lord. That is where I, my lord, distinctly say that this is not considered the de facto part. I'll show. Alone, which can be recognized as being the de jure disqualifications under the Act. De jure is, as is well settled, would mean something stipulated or prescribed by law or according to law. It would thus include disqualifications which would automatically render, my lord, I saw this word and I marked it, automatically render an arbitrator ineligible to be either appointed or to continue. These disqualifications would inevitably result in the termination of mandate. So this is automatic, my lord. That is why I said at the first, my lord, that he helped me out by these judgments. If I fall under this, it is automatic under de jure. Bias as distinct from the above would be an issue which would have to be axiomatically be established in fact. So, my lord, my onus today before this court and yesterday was to show the biasness. Once I can prove the biasness, my lord, I think it is apparent, my lord, I fall under 14. And, my lord, the 25 judgment shows, my lord, that I don't have to prove bias. I have to only show, my lord, justifiable doubts. Now, my lord, kindly sees, established in fact, an allegation of bias would have to be alleged and proven. My lord, today this is not the law. With greatest of respect, the larger bench says that I have to only show acts of biasness which may be there, which creates a justifiable doubt. Viewed in that light, it is manifest that it would be clearly fall outside the pale of de jure disqualification. Again, my lord, kindly mark, de jure disqualification. The view taken by the court stands fortified from a reading of section 12(3) of the Act, which mandates a party establishing that circumstances exist giving rise to justifiable doubt with respect to the independence or impartiality of an arbitrator. This is again, my lord, on 12(3) and de jure. The court, for the following additional reasons, finds itself unable to countenance the submissions that a bias allegation would fall within the ambit of 14(1)(a) of the fact. As has been noticed above, the subject of biased and justifiable doubt is specifically dealt with in section 12. If the court were to accord an interpretation upon sections 12 and 14 and treat such an allegation as falling within an overlap of the aforesaid provision, it would not only be contrary to well-settled rules of interpretation, but would also clearly violate the evidence scheme and the intent of the legislature. My lord, not a word, with greatest of respect, my lord, with respect to, my lord, the de facto part of the section 14. He is proceeding, the Honorable Court is proceeding on the, my lord, pretext of section 14 de jure part only. Now, my lord, kindly leaves, my lord, 35, kindly comes to paragraph 36, and kindly sees, my lord, he still proceeds with de jure only. The expression de jure as occurring in section 14 would necessarily have to be construed as conditions which are recognized and so ordained by law. My lord, no conflict with it at all. The subject of biased and justifiable doubts is clearly one which is specifically provisioned for in section 12. Once that subject stands taken note of by the legislature in the said provision, it would be tenuous to hold an allegation of bias as being one which would be triable in section 14 proceeding also, because, my lord, he is not considering de facto factor under section 14. Sections 12 and 13, when read together, thus appear to constitute a complete and an independent court for the purposes of trial of such an allegation. They clearly mandate and oblige the arbitral tribunal to examine whether circumstances exist that give rise to justifiable doubts. The factual inquiry which would necessarily have to be undertaken in connection with the aforesaid clearly appears to be controlled and governed by section 12 and 13. Now, my lord, will kindly mark, once the aforesaid issue stands governed by the aforesaid two provisions, it would be incorrect to recognize an identical inquiry being undertaken by the court under section 14. This would not only foul of the principles enunciated in HRD, it would also appear to be contrary to the legislative intent enshrined in sections 3, 4, 5 and section 13. The still, my lord, the court continues with the, my lord, view as, my lord, of de jure, and he says in 12(13), since there is biasness, it cannot be looked into 14. It does not deal with the second factor of de facto at all, with greatest of respect, my lord. Now, my lord, kindly comes to paragraph 40. In the aforesaid views as expressed in HRD Corporation finds resonance in the principles enunciated in Bharat Broadband. In the aforesaid decision 2, a clear distinction was recognized to exist between ineligibility which may be incurred by virtue of section 12(5) of the Act, read with 7th schedule. Again, my lord, de jure factor is considering, and the issue of justifiable doubt as to the independence of impartiality of an arbitrator. The de jure disqualification thus clearly appears to have been recognized to be one which would be relatable to section 12(1), 12(5) and the 7th schedule alone. If we go by this, my lord, finding, then, my lord, de facto part in section 14 will be, my lord, of no use at all. Then the legislative intent is not considered, or it shouldn't be looked into. 41, my lord, kindly see.
I think I've understood your argument, Mr.
Yes, my lord. So therefore, my lord, kindly once takes also, my lord, HRD. He says HRD says so. Kindly sees HRD also, my lord, deals with de jure.
I've seen that. But all the judgments
They are on de jure, my lord. De facto, my lord, there is not a single judgment which says that, my lord, if lordship can be shown de facto on the facts of the case, then, my lord, lordship will not entertain a section 14 application. And, my lord, kindly sees one paragraph, if I may, at the my lord, kindly sees one which I may, my lord, once read also. I read paragraph 92. There's one line which I must show, my lord, of 2025. The determination of bias does not depend, as my lord, the Delhi High Court recorded, depend upon actual proof of bias, but whether there is a real possibility of bias. That lordship has to, my lord, determine based on the facts and circumstances of the case. So here, my lord, de facto part lordship has to consider under section 14. Can there are two other judgments of the Supreme Court. I can hand one judgment, 1988 5 Supreme Court cases, which I had also laid down the law then, that biasness need not be proved, my lord. As my lord, laid down in the Delhi High Court judgment, that even if I complain of bias, I have to prove it at this stage. That is not required. That is not required.
Yes.
Just one line on the additional submission that it's a de facto situation. De facto covers situations where, because of the death of the arbitrator, there's a possibility. That is a de facto. Because, my lord, whether a arbitrator is not eligible or not, he cannot perform his functions because of bias, that's a legal question. Application, but the standard
bias is related to de jure.
Yes. Bias is related.
That is, my lord, my learned friend's submission.
That's the judgment.
So I don't think so, my lord. With greatest of respect, my lord. My lord, although my lord, lordship is not asking for this judgment, but in paragraph 26, since this issue cropped up, Supreme Court has held bias has many forms. It may be pecuniary bias, personal bias, and bias on the subject matter. It is never de jure. And in dispute or policy bias, in the instant case, we are not concerned with any of these forms of bias. So, my lord, we have to deal, as well as shall presently see, a new form of bias, namely bias on account of judicial obstinacy. So, my lord, this is against a judge. So, may I show paragraph 26? My lord, this bias lordship has to look into. This is judicial obstinacy, my lord. And that's the Supreme Court word. So, my lord, this saying that bias is de jure is absolutely not correct, my lord.
You have done a good job, Mr.
Absolutely not correct, my lord. May I just hand over this judgment, paragraph 26?
It's not required. You already have given Supreme Court on bias.
No, but then this, my lord, since this, my learned friend's submission now is bias is de jure, perhaps that is, my lord, from the Supreme Court judgment is even not correct. Because this is on a judge who acted in a manner like this. So kindly considers paragraph 26, my lord. Only one sentence I said, that bias on account of judicial obstinacy would also be, my lord, considered as bias. So it's not de jure, my lord. So, my lord, only thing is that we have argued, my lord, I think the whole morning. Now, my lord, today I think, my lord, at 5 o'clock the arbitration is. I think today, my lord, we can both parties, my lord, request that
we'll make a joint
prayer, my lord. So, lordship, my lord, then should we file a note, my lord, or something?
No need.
Right. Grateful. Great.
Probably couple of days, probably maybe. Heard. Reserved. Saving. I can, but it will take too much time if I start dictating.
We can take an adjournment today, my lord. We have both parties have argued it. We can say that to keep it next week, my lord, or whenever lordship, my lord, feels, my lord.
No, you'll have the order. CV.
So, my lord, we will keep it after a fortnight.
Yeah.
We'll pray and keep it after a fortnight.
deeply obliged.
Grateful, my lord.
Thank you, Mr. Banerjee. Thank you. What's your name?
Rohit Das.
Rohit Das. Thank you, sir. Yeah, surrender. फिर 2 बजे. Next.
My lord, item number 5, my lord, I'm appearing for the respondent.
Yes, we'll hear. Where is Mr.
My lord, I'm making that prayer, lordship, if it can be taken up tomorrow. My lord, Mr. Chaudhary is not in, he's out of station. My lord, he's requested, my lord, if
Going on and on, let's finish it, you know.
my lord, we'll definitely, most definitely finish it tomorrow, my lord. He's not here today only, my lord.
Who's
Tomorrow,
not?
my lord.
Mr. Chaudhary.
Yes, my lord, he's not here, my lord. He's requested if it can be taken up tomorrow, my lord. He'll conclude his arguments tomorrow.
I don't stand in the way of adjournment. But Let it
I
not,
want to finish it.
but let it not be said every time, my lord, that we are moving this when the contempt arises. This is then.
No. Contempt was
their
not
submission.
proceeded with.
Contempt, they are not really pushing it, right?
Yes, my lord.
That is what their submission is always, that because the
Well,
contempt came, we are moving the appeal.
Well, that was because the matter was listed the day before the contempt was listed in Rajarhat Court.
For the benefit of my learned friend, my lord, I will hand over a copy of this. This is an unreported judgment relating to section 42 and 37.
Give me.
I'll hand over a copy to my learned friend, my lord, so that they can deal with it tomorrow.
Yes.
ये फाइल में डाल देना इसको.
In the presence of Mr. Chaudhary, tomorrow I will just place that portion.
Keep it in the file.
I'll
What
place
is
that
it?
portion.
What are you showing?
This is also a 37 appeal.
37.
Arising, my lord, there was also a previous appeal to another court, and that 42 principle will not apply.
Tomorrow.
Grateful, Lordship.
This is of our court, my lord.
Learned counsel for the respondent, prays for time. Since the senior counsel, Mr. Jishnu Chaudhary, is in some personal difficulty, learned counsel Ms. Chatterjee, right?
Yes.
Ms. Chatterjee seeks and is granted time on the ground that the learned senior counsel, Mr. Jishnu Chaudhary, is in some personal difficulty. Let this
Tomorrow
matter
is
be
your
listed.
execution day, my lord. Kindly then take it up on Friday.
Oh,
Because tomorrow is an what I heard, my lord, your lordship
Yes,
takes up the execution matters.
yeah, Friday.
Friday, my lord.
Friday.
Very well, Lordship. Grateful, my lord.
Keep it in the top 3 matters on Friday. I want to finish it.
Yes, my lord. Let it be done, my lord. It will be convenient also.
Yes,
Fine.
my lord.
Top 3 matters. Just keep it so that we finish it.
Obliged, my lord.
Obliged, my lord.
Okay, দিয়ে দাও। তোমার কাছে একটা কপি আছে তো?
I think Lordship had passed an interim order, but 2 days for compliance. Lordship had directed us to invoke the arbitration clause, which we have invoked. But
Arbitrator
by
appointed?
affidavit of compliance, but this does not have the notice annexed with it, but we have the notice.
Notice doesn't solve any purpose.
The notice is with us. It has been served. The arbitration clause has been invoked in terms of the purchase order. Now, may I hand up the invocation letter?
Right, we'll extend it further for a period of 6 weeks.
Well, I've invoked the arbitration clause. May I hand up?
We get the arbitrator appointed. You have
No, well, under the IRS conditions, before a demand for arbitration is to be made, before that I have to make a representation, and that is the mandate 2902 and 2903. That is why we have made a demand before the concerned officer to adjudicate my claim. If they don't, then I have a right to demand for arbitration. So we have invoked the clause 2902, and thereafter, otherwise the invocation of the
That you
arbitration.
could have done long back. You have been
Right.
dragging your feet.
Well, before invocation of the arbitration clause under clause 2903, I have to make a representation under 2902. It is condition precedent under the clause. So otherwise, my invocation would have been bad. So that is why we have made a demand. If your lordship could peruse.
No, but this demand you could have made long back. The dispute has been going on for ages.
Various representations were made, but in specifically under 2902, nothing was made. But various representations made were made before. Various representations, and which we have annexed with the application.
After direction of your lordship, not any type of
Not
demands has
any
been
type. He's saying that he has invoked that 2902 for appointment of the arbitrator. What do you want? The appointment has to be done, then only the issue can be resolved.
Lordship, the representation of the petitioner.
Sir, what arbitration has to be conducted? He's taking steps towards that direction. What do you want?
Lordship, he has not submitted a representation before the.
That's what he's saying that he has. Maybe you don't have the instruction.
But your lordship, one line, your lordship, allow me 1 minute time, your lordship. But he has submitted on 17th November 2025 before the railway, your lordship, regarding in page number 9 of that paragraph number 55. Please also note that the mechanism for appointment of an arbitrator as provided under clause 295B of the IRS conditions of the contract is invalid in law. Lordship, they are denying the proceedings.
They have issued a letter now, sir. Give a copy of that.
He is relying on my letter itself.
Just take down. We'll extend this.
Yes, kindly. And whatever they want to do with my letter, let them reply. I'll indicate.
Yes. Replied their letters.
No, we
want to file. You want to file something here?
If you also kindly consider this letter which railway has submitted before.
Do you want to file an affidavit or something?
If lordship directs.
All right. Learned counsel for the respondent seeks and is granted 4 weeks time to file his affidavit. Full stop. Interim order granted earlier is extended further for a period of 8 weeks.
To that affidavit, I'll also give a reply, my lord. If he files an affidavit in opposition. No, not really. Very clear.
The rest of the matters after lunch. उसमें एक लाइन लिखा है. Learned counsel for the respondent has handed over a copy of the letter dated
17 November 2025.
17th November 2025, wherein in terms of clause 2902 of IRS condition of contract 2022, he has invoked the appropriate proceedings. Full stop. A copy of this letter is handed over to the learned counsel. You have the copy of this letter?
No,
But that's the latter's reply. Lordship, railway has submitted reply.
Put that in an affidavit. That's what.
Just put it on affidavit. So if you know that, so he's right, and to that extent, see the letter. See the letter.
Yes, we've disputed the.
You are disputing it, then you.
Clause. The mechanism.
Then
the mechanism now held that mechanism to arbitrary. Same judgment that Mr.
Exactly that railway judgment.
That railway judgment.
So
now that part of the clause is gone.
Then you have to go before the court.
That's right.
I have not done
Section 11.
Then why did you do that?
Your lordship's direction was I give a notice, and correctly, because unless I give a 21, I can't do a 11. So my 21, I have to say that this part of the clause is bad.
Learned counsel for the petitioner states that he shall be taking appropriate steps in filing a petition under section 11(6)
Great.
of the Arbitration and Conciliation Act within a period of 2 weeks.
No, not
If he
30 days that he has to respond to me. Otherwise, my 11 won't be right. So you'll also keep after expiry of 30 days, kindly make it. After expiry of 30 days from receipt of the
Within a
notice
period
dated
of
1711.
6 weeks.
Grateful.
List after 8 weeks.
Regarding this, then it is not necessary to file affidavit.
There's no need, but we have to wait for them. Either you write a letter and say that, we do away with this.
I have written a letter regarding that, Your Lordship, they are only.
See, now in terms of the law settled by the Supreme Court, you can't have your own arbitrator.
Then what remains the agreement?
That's not my law, sir. That is the law of the Supreme Court. What are you saying? What kind of argument is this? What remains in the agreement? You please read the judgment.
Lordship,
Then you come here, please.
Lordship,
I'm not saying this. This is the law.
Lordship, is if the petitioner.
Sir, this is the. Please. Do you brief your senior or he just comes and says anything in the court?
Affidavit is not required as they are aiming.
So that's why I said that you do away with that and both of you can get an arbitrator appointed.
Kindly that
You know
portion
that institutional thing is no longer there now.
affidavit portion may be recalled.
He has to respond to my notice under 21. If he doesn't, then as your lordship provided, I get the 30 days. If he has a response, let him give it to me. Then I'll file the 11.
He has not even responded to that letter.
He's not. We have not received anything.
Let that affidavit be there. Let them file it. All right. Rest of the matters after lunch. Judgment. Give him the judgment. mentioning slip पता नहीं यहाँ क्यों रखा है इसने useless
Regional 5 non-commercial matter for judgment, petition number 1.
Lord, I am for the respondent number 1 and
I am for the petitioners.
In view of the foregoing discussion and having regard to the clear pronouncement of the Honorable Division Bench in APO number 79 of 2021, this court finds no ground to entertain the present petition. The prayer for the reimbursement of corporation tax being post-forward liability falls outside the ambit of Section 9, which is confirmed to interim and protective measures and does not extend to the adjudication of substantive monetary claims. Accordingly, the present petition under Section 9 of the Arbitration and Conciliation Act 1996 stands dismissed with liberty to the parties to raise their respective claims, contention, defense in the pending Section 34 proceedings or in such proceedings as may be legally maintainable.
Your Lordship, the last or in any, could Your Lordship kindly just repeat that last portion? Section
With
34.
liberty to raise their respective claims, contentions, and defenses in pending Section 34 or in any other proceedings.
Grateful, grateful, Your Lordship.
Date क्या 26 26 है ना 26 है ना डेट
Supplementary item number 1.
My lord, I appear on behalf of the award holder.
इनको ओथ दिलाने के लिए कौन है
My lord, I am appearing on behalf of respondent judgment debtor, my lord.
Yes, why he's not making the payment? Why he has not filed the affidavit of asset?
My lord, just now the case is transferred to me, my lord. On by next day, I will submit affidavit of asset and liability. my lord.
ये पैसे दीजिए आप पैसे क्यों नहीं दे रहे हैं Why you are not making the payment? क्या हिंदी इंग्लिश क्या आता है
Bengali.
Only Bengali?
Only Bengali.
कहाँ है वो where is the translator?
My lord, whatever my client submitted before me, that is that they borrow a truck for some loan amount, but after that they could not run this business, my lord. That's why they could not make the payment, my lord. But they till now they own the truck, my lord.
They own the truck.
Yes, my lord.
The hypothecated asset is with them.
Asset with them, my lord.
At least hand it over or negotiate with them, finish it off.
Yes, my lord. We'll try, my lord, to negotiate.
कहाँ है भाई ओथ देने के लिए कोई आए क्यों नहीं है Just read out the is the oath there? The copy. कहाँ oath का copy कहाँ है?
May I submit my Gokalatnama before court? Yes, ma'am.
Just now. Message.
বাংলা
আমি বলুন।
হ্যাঁ বলেন সালাম।
আমি
আমি
এই মামলায় সাক্ষ্য দিতে এসে যা কিছু বলবো সত্য বলবো সত্য ছাড়া মিথ্যে বলবো না কোনো কিছু গোপন করবো না। আপনার নাম বলুন।
আমার নাম সেন্টু শেখ। SE
নামটা বলুন।
SENTU।
বাবার নাম বলুন।
শীষ মোহাম্মদ শেখ।
বয়স
আমার 45 বছর।
কি করেন?
গাড়ির ব্যবসা ছিল, এখন বেকার স্যার।
earlier I had vehicle. No? Address বলুন।
বাড়ি ভিলেজ পোস্ট রতনপুর, PS শামসেরগঞ্জ, ডিস্ট্রিক্ট মুর্শিদাবাদ।
3 নম্বর বুক।
742202।
আপনার যে সম্পত্তির হলফনামা আছে সেটা উকিলের দ্বারা এই আদালতে ফাইল করতে হবে। ঠিক আছে? যদি আর যে ডেট দেওয়া হবে সেই ডেটে আসতে হবে।
আসবে স্যার।
না আসলে পরে আবার অ্যারেস্ট করে নিয়ে আসবে।
না স্যার, আমি নিজে থেকে এসেছি, মানে আমি আগে জানতে পারিনি, স্যালেন্ডার হয়েছিলাম নিজেই।
My lord, may there be direction upon the
আমি নিজে
judgment data number 1 to file affidavit of assets on behalf of judgment data 2?
Yes, my lord. I will file by next date, my lord. কারণ ডিপার্টমেন্টে তোমাদের মামলাটা লিখেছে কম্পিউটারে চোলামন্ডলা ভার্সেস সেন্টু শেখ। এদিকে কস্ট টাইটেল হচ্ছে সেন্টু শেখ অ্যান্ড কি একটা ফিরদৌসি বিবি। এবার সেটার জন্য ডিপার্টমেন্ট কিছুতেই নিচ্ছে না। হ্যাঁ, না কস্ট টাইটেলে না, তোমাদের কম্পিউটারে যে না অর্ডার শিটে আনাদার নেই।
হ্যাঁ, order sheet another. হ্যাঁ, order sheet another.
Yes, my lord, 15 days waiting. Order.
My lord, this is my section 9 application. My lord, the service upon the respondent is not clear. I'm praying for a fresh service.
Learned counsel for the learned counsel for the petitioner states that seeks and is granted 2 weeks time. 2 weeks?
2 weeks, man.
2 weeks time to effect service upon the respondents. Respondent or respondents?
My lord, respondents. There are 3 respondents.
Respondents. Let this matter be adjourned for a period of 4 weeks.
My lord, may I be permitted to file the notice of motion and the affidavit of service?
Affidavit of service, you're saying it's not been served?
It's not been served. The notice of motion, it has not been filed with the court.
Notice of motion. Take the notice of motion to ले सकते हैं. Notice of motion is taken on record. No, but if you without affidavit of service, how are you filing the notice of motion?
My lord,
Give it
I'll
back.
then file afresh.
Give it back.
Article 5 commercial matter, item number 8.
This is my section 9 application.
Yes.
This has been served on the respondents. My lord, I have prepared a chart for your lordship's reference.
Take down. The petitioner has filed the
affidavit of service.
present application
Affidavit of service.
under Section 9 of the Arbitration and Conciliation Act, seeking a direction upon the respondent to furnish adequate security for the alleged outstanding dues payable to the petitioner, full stop. In the event the respondent fails to furnish such security, comma, the petitioner seeks an order of attachment of the respondent's bank account as detailed in Annexure E. It is the case of the petitioner that a credit facility of rupees 20 lakhs was extended to the respondent pursuant to a loan agreement dated 10th January 2024, comma, repayable within 48 months along with an interest at the rate of 15% per annum. Full stop. The respondent allegedly defaulted from the 16th installment onwards, full stop. Consequently, comma, the petitioner terminated the loan agreement on 17th July 2025 and demanded a sum of rupees 15,81,128.71, full stop. As the respondent failed to make the payment, the petitioner referred the dispute to the online dispute resolution platform on 28/7/2025, comma, where an arbitrator was appointed on 30/7/2025, full stop. However, comma, the respondent objected to the said appointment, comma, leading to the arbitrator recusing himself, vide letter dated 22/8/2025. Full stop. The petitioner submits that steps are being taken for appointment of another arbitrator, full stop. Meanwhile, the outstanding dues have accumulated to rupees 16,44,325.04, full stop. Hence, the petitioner has filed the present petition seeking direction against the respondent to furnish adequate security for the said outstanding amount, comma, failing which the bank account mentioned in Annexure E to be attached. Learned counsel for the petition relies on clause 8 of the loan agreement dated 10/1/2024, which contains the arbitration clause, full stop. It is further stated by the learned counsel for the petitioner that the entire transaction took place within the territorial jurisdiction of this court, comma, therefore this court is competent to entertain the present petition. Full stop. None appears for the respondent. I don't want to attach you serve them once more.
Sure.
Learned counsel for the petitioner seeks and is granted one more opportunity to serve upon the respondent. पहले लिख लेना. Affidavit of service taken on record. None appears on behalf of the respondent. Learned counsel for the petitioner undertakes to serve again the respondents. Seeks and is granted 2 weeks time to serve the respondents. Respondent or respondents? One
Respondents.
Respondents. List after 3 weeks.
Grateful.
Commercial item number 9.
My lord, before my learned friend starts, my lord, I have just received an instruction over telephone. The respondent is based out of Delhi, my lord.
Yes.
The authorized representative is on his way. He's coming today evening. My lord, I was seeking a day's accommodation. My lord, I have not.
All right, not today, tomorrow.
My lord, may it be on 2nd of December or any day after, my lord, 1st December, my lord.
Why? What happened?
my lord, 1st December, my lord, is the monthly list day. That's why, my lord, we want to have. If my lord kindly keeps it on 2nd,
Why not
subject to my lord's kind convenience.
All right, 2nd December.
Grateful.
Not today. Not today, 2nd.
Grateful.
Obliged.
Wait, please, my lord. This is my Section 9 application, my lord.
Yes.
My lord, I'm moving this ex parte out of compelling urgency, my lord. The petitioner before your lordship, my lord, is SRMB, my lord. I'm engaged, my lord, in the business of manufacturing TMT steel bars, my lord. What my business, my lord, contemplates is that, my lord, I engage into unit franchisee agreements, my lord. The scenario, my lord, is that in any particular region, my lord, I identify, my lord, a manufacturer of TMT bars, my lord. I give them the technical expertise, know-how, my lord, my IPR rights, a limited, my lord, assignment of my IPR rights, my lord, and I give them, my lord, the software which they use to manufacture the TMT bars, my lord. A similar engagement, my lord, had been entered into in the facts of this case, my lord. The parties, what they do, my lord, in breach of the agreement, my lord, they use my IPR rights, my software, and my expertise to manufacture their own goods in those territories, my lord, for which the agreement is entered into. And when I confront them, my lord, now they've issued a letter to me that they will dissipate off all those properties that are in their custody and possession as an attempt to, my lord, supposedly mitigate their losses. My lord, that is the urgency, my lord, which is why I'm moving ex parte.
So have you served them?
No, my lord, I have not served them, my lord. I intend to, my lord, move this ex parte, my lord, because the moment I give them notice, my lord, they will sell off the properties. There's an email, my lord, to that effect that they will do so imminently. May I directly show your lordship that particular email, or should I, my lord, indicate, my lord, the specific clauses that they've acted in breach of?
Sure,
my lord. My lord, kindly takes, my lord, the agreement. My lord, the agreement. My lord, the agreement starts from, my lord, page 58, my lord. My lord, only the relevant clauses, my lord, I'll just briefly indicate. My lord, kindly takes, my lord, page 64, my lord. Running page 64, my lord. Subclause 16, my lord, territory.
Subclause?
Subclause 16, my lord. That's at page, running page 64, my lord. Internal page 6 of the agreement.
Yes.
Territory, my lord. Territory has been defined as means the designated districts in the state of Gujarat, details whereof have been given in Annexure A, my lord. These are specified districts in Gujarat where, my lord, under this agreement, they were supposed to manufacture TMT bars under my name, using my brand, and as per the specifications of this agreement, my lord. My lord, this agreement, the consideration of this agreement, my lord, was, my lord, royalty. Twofolds, my lord, royalty and security. They had to pay a royalty, a lump sum amount of royalty, for which, in consideration of which, I was supposed to give them a limited assignment of the IPR rights and, my lord, furnish security. Those clauses your lordship will find at internal page 12 of the agreement and running page 70. Your lordship may take a note of it, but your lordship can take it that is what the clauses says. That's Article 7. Consideration and other remuneration. They have not done so. Out of 35 of total security deposit that they were supposed to make, they do not. That's on record, my lord. They have never denied that they have not done so. They've also not paid the unit, the royalty payments. That is also on record, not denied or disputed on the matter of on the basis of correspondence on record. The other twist, my lord, comes is where we discovered upon inquiry that they have been using our IPR rights, our software, and our expertise, and the critical information that we have provided them, that's confidential under this agreement, for manufacturing of their own goods. That your lordship will find an email that we had issued to them, and I'll show the response to that as well, that your lordship will find at page 111, your lordship. An authorized representative from my company, my lord, issues a letter. First, indicating, my lord, the outstanding financial dues of royalty and security deposit, my lord, that I already indicated. The second, my lord, is breach of contract. This is where, my lord, I would like to place some emphasis on. It has been established. May I place that, your lordship? It has been established that material has been sold to retail counters across Saurashtra. My lord, that's the territory under the agreement. Saurashtra directly from Sanjay Ferro Metals Private Limited, the respondent before your lordship. This constitutes a serious breach of trust and violation of the agreement carried out without the knowledge or consent of SRMB. Such actions have undermined our investment, manpower, and efforts in the territory. Furthermore, it has been observed that Sanjay Ferro Metals Private Limited sales personnel are promoting the Sanjay Ferro Metals brand in the Saurashtra region, thereby curtailing SRMB's brand image and sales volume. This practice is completely unacceptable, and then we call upon them to do certain acts, none of which have been done so. To the contrary, they issue a reply saying that we understand that there are certain difficulties going on in our relationship. Please give us more time and please issue us more orders so that we can we can distribute in the relevant market. Kindly takes the response, my lord. That is at page 110. Right the page before. It's a trail mail, my lord, that has been annexed. Right at the bottom of that page, my lord. Kindly notes, my lord, right at the bottom of that page, an email of 3rd September 2025 issued by Abhishek Rathore, my lord. In reply to that email, dear sir, we have been informed by SRMB management to hold dispatch until further notice. Currently, there are pending orders and bookings amounting to so and so. Distributors are regularly seeking updates on dispatch and delivery timelines. If the dispatch continues to remain on hold, it will be difficult for us to respond to the sales team so and so. Prolonged delays may also impact customer confidence and could affect the market perception of the SRMB brand. No denial, no repudiation. I will inform your lordship the context for why they have written this. Because they refused to make royalty payment, my lord, we stopped sharing, my lord, quotas for which they were supposed to make effect supplies, my lord, in that region, because they did not make royalty payment. Then upon inquiry, we discovered that they had actually used our expertise and our materials to make effect of their own sales plan. Your lordship will next consider the clauses of the agreement that they've breached only on the basis of this correspondence alone. The agreement contemplates twofold obligations, my lord: non-compete and absolute confidentiality.
Sure.
Kindly, my lord, takes the non-compete clause that your lordship will find, clause 36, page number. Your lordship will find that at page 76 of the petition. Clause 36, your lordship. May I place it? The franchisee shall not, which is Sanjay Ferro, the respondent before your lordship, the franchisee shall not sell, promote, or distribute any products under its own brand using SRMB's distribution channels or within the assigned territory. In the event of a breach of this clause, the franchisee shall be liable to pay a penalty of 100% of the sales value per violation. The franchisee reserves the right to take further legal action, including but not limited to termination of this agreement and claims for damages. I have terminated. I'll place that letter as well, your lordship. Next, kindly takes, my lord, an ancillary obligation, clause 50, at page 78. This is a bar against co-branding. May I place it? The unit franchisee shall not engage in any co-branding activities, it would be activity, under SRMB's brand ambassadors, trademarks, logos, or marketing collaterals without prior written consent from the franchisor. Any violation of this clause shall result in a penalty per instance. The franchisee reserves the right to take further legal action, including but not limited to termination. Now, my lord, I'll directly invite your lordship's attention, my lord, to the termination notice. And, my lord, then the consequence of termination, for which, my lord, I'm before your lordship seeking ex parte ad interim release. Kindly takes, my lord, page 112 of the application. I will not bother your lordship by placing the entire termination letter. My lord, I've particularized there the breaches that they have committed. That your lordship will find at page 115, para 5 of my termination letter. Formulated each and every specific instance of breach under this agreement. Since due to the recurring nature of the breaches, we were compelled to terminate. The agreement provided for defaults twice. If there was consequential defaults concurrently in twice separate occasions, we could terminate. It's more than twice, as tabulated here. And then, my lord, kindly takes page 116 once. I won't trouble your lordship any much further. Page 116, para 8, my lord, I call upon them to do certain things, my lord. This is in line with what the agreement itself contemplates. post-termination obligations. Cease and desist, my lord. And then return on all SRMB materials, my lord, settlement of accounts and destruction of SRMB articles. Not done so. What they have done is then they have issued a letter, my lord, while my termination notice was in transit, they issued a letter saying that we are suffering losses. They are apparently suffering losses because the goods, my goods, were lying in their custody and they plan to sell it off. I'll directly indicate that letter, your lordship, that your lordship will find at page 121. This is of some relevance, your lordship. Kindly notes the date, November 19, 2025, this has been issued, and my termination letter was on 18th of November. Even if I give them the benefit of the doubt that they had not received my termination letter, the tenor of the letter itself indicates that there is grave urgency. Under the garb of a supposed settlement, your lordship, they're suggesting that they will sell off the goods which I've asked them to not only use but also destroy.
Yes.
And my lord, only the arbitration clause, since it may fall from your lordship to the issue of jurisdiction, my lord, kindly takes the arbitration clause. That's Article 26 of the agreement, page tabolo. That your lordship will find at page 98 of the application. Seat venue both Calcutta, and only the courts at Kolkata alone will have jurisdiction for any dispute arising out of this agreement.
All right. Take down. The petitioner has filed the present petition under Section 9 of the Arbitration and Conciliation Act, seeking interim protection in the form of 1. I karo. Roman 1. Appointment of receiver to take over, preserve, maintain, preserve and maintain all properties and articles of the petitioner under the SRMB, inverted comma kar dena, mark and brand, as specified in Schedule A and capital A, and presently lying in the custody of respondent, full stop. Roman 2, an injunction restraining the respondent from exploiting, using or dealing with the petitioner's SRMB, inverted comma mein S capital, R capital, MB capital, logo, comma, SRMB formative device, label mark, trade dress, and associated intellectual property as detailed in Annexure A, right?
Yes, ma'am.
A, comma, pending the conclusion of the proposed arbitral proceedings, full stop. It is the case of the petitioner that he is engaged in the manufacture and sale of TMT steel bars under the SRMB brand, full stop. Under the unit franchise agreement, this is dated
11th of March 2025.
11th of March 2025, comma, the respondent was granted a limited, comma, non-exclusive license to manufacture and sell SRMB products in designated district of Saurashtra region, comma, subject to strict compliance with the agreement, full stop. The petitioner terminated the agreement on.
We terminated on, my lord. The letter we have issued on 18th of November.
The petitioner terminated the contract by a letter dated 18/11/2025 and directed the respondent to cease all operation under the SRMB brand, comma, return all materials, comma, documents, comma, articles and collateral belonging to the petitioner, and destroy any residual material in its possession, full stop. Despite receipt of the said notice, the respondent allegedly failed to comply and threatened to unauthorizedly deal with the petitioner's branded material for commercial gain. Full stop. The petitioner asserts that upon termination, the respondent has no right to retain or exploit any of his intellectual property or branded material belonging to the petitioner. Full stop. The petitioner intends to invoke the arbitration clause as per the agreement. Full stop. As the agreement confers exclusive jurisdiction upon the courts in Calcutta, this court is vested with jurisdiction to entertain the present application under Section 9 of the Arbitration and Conciliation Act 1996. Full stop. This court has heard the argument advanced by the counsel for the petitioner, Mr. Sen, and has examined the materials placed on record. Full stop. The petitioner has made out a strong prima facie case. Full stop. Documents on record, including the termination notice dated 18/11/2025 and the correspondences that followed, demonstrate that the contractual license granted to the respondent to use the SRMB brand stood terminated. Full stop. Upon the termination, the respondent's right to use, possess, or deal with any material or intellectual property of the petitioner automatically ceased. Full stop. The respondent's failure to return the petitioner's property and the alleged threat to sell or commercially exploit the SRMB branded material support the petitioner's contention that immediate protective measures are warranted. Full stop. The balance of convenience lies overwhelmingly in favor of the petitioner. Full stop. The material and intellectual property in question solely belong to the petitioner and were provided only to use within the limited framework of the agreement. Full stop. Permitting the respondent to retain to use such material post termination would not only violate the contractual terms but may also lead to dilution and misuse of the petitioner's dilution and misuse of the petitioner's brand, cause confusion in the market and result in commercial and reputational harm to the petitioner. Full stop. The respondent suffers from no prejudice by returning the property that is admittedly not its own. Full stop. The exploitation of the SRMB brand, trade dress or related material by a terminated franchisee would directly impact the petitioner's brand identity, goodwill, and market reputation, injuries which are intangible and not capable of adequate compensation in monetary terms. Full stop. Further, any unlawful disposal, misuse, or tampering with the SRMB brand material would cause irreparable loss and compromise and will compromise the integrity of the brand. Full stop. Such injury cannot be restituted at a later stage, even if the petitioner ultimately succeeds in the arbitration proceedings. Full stop. In the light of the above findings, so and so is appointed as a receiver to take over, preserve, and maintain all properties, materials, articles, properties, material, article, and collateral belonging to the petitioner under the SRMB brand as mentioned, as detailed in Schedule A, comma, presently in the custody of the respondent, full stop. The receiver shall take immediate possession of the said items, full stop. The receiver's remuneration is fixed at,
I leave it entirely to your lordship.
this is outside, right? So outside would be generally how much is,
I leave it entirely.
no, I know, but generally what is the trend?
Fortunately, I'm a bit handicapped in this.
Mr. Sen?
We leave it to your lordship, my lord. 50, 25, whichever your lordship decides, we leave it entirely to
Oh, you're a rich brand. 75,000. 75,000 to be borne by the petitioner, full stop. A representative of the petitioner shall accompany the receiver, and all expenses including travel, air flight, including travel and lodging shall be paid by the petitioner in advance, full stop. The respondent is restrained from using, exploiting, and or dealing with any manner whatsoever with the petitioner's SRMB logo. Anything else?
all the articles also, they may also
SRMB logo,
articles lying
full
in their
stop.
possession.
Logo, SRMB logo, trade dress, and intellectual property as described in Schedule A for a period of 4 weeks. For a period of 4 weeks from today, full stop. The receiver shall make an inventory and keep the goods in a.
Yes, there's a prayer, my lord, in the application that he may also my lord, liquidate them and put it in a nationalized bank so that, my lord, we may have a chance at mitigating the damages of whatever arbitration proceeding, my lord, we take. I leave that entirely to your lordship. I leave that to your lordship.
That we'll do it later.
Yes, ma'am. But the timing, my lord, he can keep it in his custody.
And keep the goods in a custody. In his or her custody. Full stop. The petitioner shall make all endeavors to initiate the arbitral proceedings, to invoke the arbitral proceedings in accordance with law.
I'm deeply obliged. Deeply obliged.
This will be returnable after, or shall we just dispose it off, or you want it to be?
My lord, we'll come back with the Section 21 notice, my lord. And
after 4 weeks, after 6 weeks. Let it be after 6 weeks, then we'll dispose it off.
Deeply obliged. Deeply.
Commercial item number 11.
Yes.
So this is the matter where your lordship was, my lord, confronted with the question as to, my lord, whether it has been filed in the commercial division or not.
Like to, whatever submission I have made, I have prepared a short note, my lord. Let it be on record, my lord.
Why you make a submission, overall submission? I'll deal with that.
Yes.
Why only this one?
No, this, my lord, is a separate issue on the demurrable issue.
I shall deal with it in the course of, my lord, my arguments.
My learned friend has already made his submission on that.
No.
On the demurrable issue to bolecho. Eta ki dekhale je? That my learned friend has submitted.
My lord, we will, my lord.
Mr. Saha might would like to.
Yes.
Anything else, or shall we?
No, my lord. So on the main merits of the matter, I have to yet address your lordship.
Please, let's
Yes.
start with the merit.
My lord, there's only one difficulty. I don't know, my lord, whether your lordship, my lord, will be taking it, my lord, beyond 3 o'clock, because I understand there's another bench.
Let's take it beyond 3 o'clock if both of you agree.
Well, my only difficulty, there's a continuing part-heard matter fixed before court number 8. My lord,
They will not hear it after 8, after 3:30. I mean.
No. I'll see. Now, my lord, if your lordship, my lord, has a
Let
look.
my notes be kept on record.
We'll take it.
Yes.
Yes.
Well, lord, my challenge is to a part of an award. I had made, my lord, 4 several claims. 2 claims have been allowed. 2 claims have been disallowed. Now, my lord, my primary challenge is.
This is your affidavit in opposition. You have got a copy of this.
Affidavit in opposition? Yes, sir.
Affidavit in opposition filed by the Respondent is taken on referred.
To the section 34.
Let's go down. Yes.
My lord, may I start with the award itself?
Yes.
Well, your lordship will find, my lord, that at page 48. Where I shall, my lord, interchangeably refer, my lord, to the award and to the contract entered into between the parties. My lord, please have a look at, my lord, page 48. My lord, this is the award. My lord, this sets out very briefly the background. May I show your lordships the background of the matter. Kolkata Metro Rail Corporation awarded the contract such and such for design construction of underground section from Central Station to Subhash Sarovar to ITD. Well, that is the petitioner before your lordship. Well, the total amount was INR 8 billion, that's 156 million, etc. Now, well, please note, well, here the completion period was 17 weeks from the commencement date.
Where are you reading, sir?
I was reading from clause 1.0 at page 50.
Yes. 217 weeks.
Yes, my lord. Contract is, my lord, for a fixed, my lord, sum initially. Completion period is 217 weeks from the commencement date, as stipulated in the notice to proceed. My lord, this notice to proceed is, my lord, the letter of acceptance between the parties. The time, my lord, is also specified. My lord, 217 weeks is from 9th of February 2010 to 8th of April 2014. Well, I'll pause here for a moment. My lord, when, my lord, the time for performance of the contract is fixed, then, my lord, normally, my lord, a contractor is supposed to mobilize his men, machinery, and, my lord, also to, my lord, identify his costs. Because, my lord, when he's bidding for a project of this magnitude, my lord, then he, my lord, makes a provision for, my lord, administrative costs, on-site costs, my lord, of overhead, my lord, expenses, etc. And, my lord, these are all recognized principles, recognized in Hudson's, MD's, actually, my lord, these formulae are well established. Sometimes the lordships have accepted the Hudson's principle, sometimes the MDM, sometimes the HT. Because, my lord, you cannot otherwise quantify it in exact terms. Now, my lord, here, my lord, we proceeded on this premise that, my lord, the time for, my lord, performance would be fixed. Why? Because, my lord, there was a representation made at the commencement of, my lord, the contract, my lord, in pre-bid meetings, that, my lord, the site is ready for handover. And, my lord, there is no other impediment that really will stand in the way. Now, my lord, I'll just show your lordship one, my lord, paragraph, my lord, in this regard. If your lordship will kindly have a look at, or I shall come back, my lord, I don't want your lordship to traverse between volumes. Now, my lord, I shall show your lordship that in the pre-bid meeting that was held between the parties, a representation was made to the effect that, my lord, all our site is ready for handing over. Now, my lord, this, my lord, question was raised in the pre-bid meeting specifically, my lord, because naturally the contractor wanted some assurance that, my lord, we will be able to proceed with the contract in due dispatch, with due dispatch. Now, so far as this is concerned, however, what had happened in course of things is, my lord, site could not be handed over, and there were various other disturbances, my lord, that prevented the work from commencing. My lord, the period of contract was initially 4 years, my lord, that spread over to an additional 5-year period. And, my lord, for this period of overstay, my lord, there were additional claims made on account of administrative costs and expenses. Now, my lord, we have not made any claim on account of idleness of men or machinery. My lord, because so far as that is concerned, my lord, we have ultimately absorbed that within the cost of, my lord, our contract. But, my lord, what we have not been able to compensate ourselves for is, my lord, the overstay, the period of overstay in the contract. Now, my lord, so far as this is concerned,
Period of
overstay, my lord, overstay of 5 years. My lord, which, my lord, your lordships have held is, my lord, a claim that can be made under a contract of this nature, and which your lordships have ultimately also accepted can be awarded by following, my lord, the principles that have been established. Now, my lord, so far as this is concerned, my lord, coming back to the award, kindly see, my lord, what is the dispute that arose between the parties. My lord, please see now clause 1.4. 1.3 first. Well, after the signing of the contract, a general consultant was appointed by KMRCL.
Myself.
Yes. Then, my lord, 1.4. Many factors, this is very important, many factors. Example, delay in handover of land, diversion of uncharted utilities, removal of uncharted obstructions or utilities, employer variations, then local restrictions, etc. impeded the progress of the work of the project. Extension of time was requested by the claimant and the respondent granted unqualified UTs. That's extension of time with details is under. Well, what this effectively means is that, my lord, we were not held to be at fault. An extension of time as prayed for was granted. Now, my lord, kindly see, my lord, the nature of extension granted. First extension of time, my lord, was granted, my lord, up to 31st December 2016. Second extension of time is granted up to 30th June 2018. Third extension of time is granted up to 30th June 2018, my lord, for one part of the work. And fourth extension of time is granted till 28th February 2019, phase 1. Now, my lord, the contract price was subsequently revised due to alteration in route. Now, my lord, this revision in the contract price was not made on account of, my lord, overstay or delay. It was made because of the revision in route, and that is an admission in the award. The contract price was subsequently revised due to alteration in the route of the underground 2 tunnel with the amendment order number such and such dated 8th November 2016 with consent of both parties. And final price was fixed at INR 1279.8102,403, including euro component and provisional sums, but exclusive of all other variations, price escalations, and abortive works and non-schedule items. Now, your lordship will kindly, my lord, make a note of this. My lord, when, my lord, the contract price is revised, it is revised only on account of alteration in route. That's number 1. And number 2, my lord, this is a final price that is fixed, my lord, without, my lord, taking into account all other variations, because it says exclusive of all variations, price escalations, abortive works, non-schedule item of works. So, my lord, this is how the price is now determined. Now, my lord, your lordship will kindly see how, my lord, the price has been impacted here. My lord, please see the table after 1.5, my lord, which depicts the changes.
Yes.
Now, original contract price is 908.63. Then, my lord, there's a deleted component of the work. So, my lord, 250.68 is deleted. Then there's a revised added component of the work, my lord, from Shubha Shorabat to Fulbagan, Shialda. So, 657.95 crores is added. Then, my lord, phase 2 of the contract, there's an addition, 621.86. So, the total revised contract price now becomes 1279.81. So, my lord, there's some deletion, there's some, my lord, addition, and it is on account of, my lord, change in scope, not on account of, my lord, overstay. The claimant sensed that due to grant of unqualified extension of time by the respondent for phase 1 part of the work from April 2014 to February 2019, well, that's almost 5 years. The claimant has incurred and or has been incurring cost overrun on account of idle infrastructure and establishment costs. So, my lord, this is on account of, my lord, idle infrastructure and establishment. The claimant issued notice of dispute against 4 items of claims invoking clause 17.4 of the general conditions of contract by letter dated 25th June 2018 and 10th July 2018. Now, my lord, naturally, my lord, I will give a notice of dispute when, my lord, I find that, my lord, the time has become, my lord, almost limitless. And, my lord, naturally, my lord, there's a cost that is involved with my lord, continuing to remain at site. So, my lord, it is then that I, my lord, invoke the arbitration clause and, my lord, give notice of dispute. Then, my lord, 1.8 and 1.9 are not really material because there's a my lord, reference requirement in conciliation, which is fulfilled, and thereafter, my lord, the arbitration is invoked. Now, your lordship will kindly, my lord, ignore 2.0 because that is, my lord, the constitution of the tribunal and other things. My lord, 3.0 is adjudication of the claim on merits. Now, my lord, please have a, my lord, let me show this to your lordship a little, my lord, slowly. The claimant raised 4 claims as detailed below by their 4 notices dated 25th June 2018 and 10th July 2018. The notice for reference to conciliation dated 16th July 2018, the notice for reference to arbitration dated 20th August 2018, and reminder dated 29th September 2018, and finally through their SOC at the arbitrary tribunal. Now, my lord, the total quantification of the claim your lordship will find from, my lord, this table is, my lord, 208 crores 91 lakhs 74,988. Now, my lord, here the first claim on account of unrecovered additional establishment cost due to extension of phase 1 part of the work. Well, that is, my lord, the first claim. Well, this has been rejected in totality. Claim number 2, on account of loss suffered due to arbitrary reduction in overhead percentage in respect of phase 1 part of the work. Well, this claim has been allowed.
This has been allowed.
Well, 2 has been allowed. 1 has been rejected, 2 has been allowed. 3 allowed.
Yes.
Then, my lord, claim number 3, claim on account of loss of interest in respect of excess recovery and prolonged withholding of retention sum in respect of part 1 of the work. My lord, this has also been allowed. And, my lord, 4, which is claim towards lost interest due to wrongful recovery of interest on mobilization advance, this has been disallowed. I'm sorry, my lord, my mistake. My lord, 1 and 3 have been disallowed, 2 and 4 have been allowed. My mistake, my lord, I'm sorry. Now, my lord, so far as claim number 1, which has been disallowed, my lord, I make no complaint naturally with my lord claim numbers 2 and 4 because they have been allowed in my favor. My lord, so far as claim number 1 is concerned, let kindly have a look at, my lord, how the tribunal proceeds. This claim is on account of unrecovered additional establishment costs due to extension of phase 1 part of the work. The claimant's contention submitted through SOC and rejoinder, as well as through presentation and response to questions. The claimant presented that extension to completion time of phase 1 part of the work happened due to late handover of hindrance-free work sites by the respondent. The claimant cited correspondence made during pre-bid conference. This is very important. I should show your lordship this correspondence. The claimant cited correspondence made between during pre-bid conference, and the claimant feels that an assurance was given to the bidders that all the works are assumed to be ready for possession on the date of commencement of the works. The claimant has submitted comparative tabular information to show difference between the date of handover as per contract and actual date of handing over, highlighting delay in handover of work sites. Actual duration of delays in various subcomponents of works has been submitted in paragraph 32 of the statement of claim. The claimant has enumerated many factors apart from delay in handover of work sites, which contributed to delays in completion of works, resulting into need for extension of time. Copies of 4 cases of extension of time were submitted by the claimant for effective extension of time for about 2152 days, that is 307 weeks, till 28 February 2019 with regard to phase 1 part of the contract. In all 4 cases, the respondent has granted unqualified extension without levy of any penalty to the claimant. The claimant feels that the respondent should compensate the claimant for any cost overrun consequent on the delay in handing over of work sites, etc. The claimant has worked out monthly average actual establishment cost of manpower, machinery, site, transport, travel charges, depreciation, etc. at rupees 269.29 lakhs for the period from April 2010 to December 2017. That is in 95 months. The claimant submitted all relevant records and documents with regards to such establishment costs before a chartered accountant who has certified the calculation before this examination. So, my lord, just pausing here for a moment, my lord, all proof of what was, my lord, the average cost, establishment cost per month, my lord, is submitted, certified by a chartered accountant, and my lord, it is not stated that, my lord, this is, my lord, unreliable. The claimant feels that the average monthly establishment cost so worked out should be used to work out the compensation to them for the period of extension granted for which the claimant was not responsible. Well, this is the claimant's, my lord, case as summarized in the award. Respondent referring to clauses 8.3 and 8.4 of the GCC, which neither permits vitiation of contract nor any compensation for any delay during presentation by the respondent, on 28th and 29th June 2019, the claimant revised their previous stand and submitted that clause 8.3 of the GCC is not enforceable on the following counts. So, my lord, the reliance was placed by the respondent on clauses 8.3 and 8.4 of the GCC my lord, without referring to other relevant clauses, which I shall, my lord, show to your lordship. My lord, our contention was that, my lord, GCC, my lord, clause 8.3 is not applicable. Let first of all, as it suffers from ambiguity, it does not stipulate the outer limit or boundary. My lord, what was, my lord, stated here, my lord, with the greatest respect, is, my lord, that you can't leave it an indefinite period. You can say that from period X to period Y, if there's delay, in that case, I shall not compensate you. But when you make it an indefinite period, and, my lord, it can stretch to infinity, in that case, it becomes unreasonable as a clause. My lord, that was the argument advanced. The word used in clause 8.3 is unspecified and uncertain. Section 29 of the Contract Act provides that an agreement, meaning of which is not certain or capable of being made certain, is void. The delay is more than 5 years as of now and is likely to be more as against contractual time period of 4 years. Now, I shall just, my lord, request your lordship to, my lord, just reflect on this. My lord, these were, my lord, the objections raised. One was, my lord, there is no outer limit specified. The, my lord, clause, therefore, my lord, becomes unspecified and uncertain. And reference was made to, my lord, section 29 of the Contract Act, which says, my lord, the contract must be certain. It can't be, my lord, left uncertain. My lord, your lordship will find that, my lord, from the, my lord, reasoning portion or analytical portion of the award, there's no reflection on this at all. There's no deliberation. Well, I can understand the tribunal goes into the question, finds it is not, my lord, a reasonable, my lord, answer to the claim, my lord, rejects it. But, my lord, if you do not choose to deliberate on this at all, then, my lord, the question is, what is, my lord, the net impact of that in an award?
Yes.
Then, my lord, your lordship will kind of have a look at, my lord, the next, my lord, page 57, Roman 9. The claimant referred to 2 Supreme Court or High Court High Court judgments in support of their claim. Well, the case of K. Satyapalan versus State of Kerala, the Supreme Court held that once it was found that there was delay in execution of the contract due to the conduct of the respondent was liable for the consequences of the delay, namely increase in prices. In the case of Union of India versus Suraj Infrastructure, the Delhi High Court, this should be Bombay High Court, right? Suraj?
It's a truncated portion.
In the case of Union India versus Suraj Infrastructure, I think, well, it's wrongly mentioned as Delhi High Court. I think it should be perhaps Bombay High Court. It's a Bombay High Court judgment, wrongly referred to as the Delhi High Court here. I'm sorry. Yes, Suraj Infrastructure, the Delhi High Court held, it should be Bombay High Court. In every matter, it is difficult to say that the tribunal and the court is prohibited totally to grant compensation if the case is made out and proved that the delay for execution of the work was due to conduct and or act of the other side. Apart from citing GCC clauses against any possible relief against the extension of time and the respondents raising dispute with regard to the CA's certificate not sustainable in the absence of any contrary law of evidence, the claimant has submitted that establishment cost can also be ascertained by using the universally acceptable Hudson's formula, Emden's formula, and Eichler's formula. The claimant has worked out establishment cost by all these formulae and ascertained their claimed establishment cost is much lower than the cost worked out by reference to the universal formula. In response to questions of the arbitral tribunal on idling of resources, manpower, and machinery, the claimant has submitted that the baseline program did not envisage any level of resources. As per the contract condition, resources could have been demobilized on instructions of the engineer, but no such instructions were received by them. Deployment of resources was made in its entirety to achieve target timeline completion. Deployment of resources in respect of phase 1, phase 2 of the project is not interrelated or interchangeable. Claim number 1 is not due to idling of resources, but is for unrecovered additional establishment costs. Well, just to explain, my lord, what had fallen from the tribunal. The tribunal's query was, do you have any particulars of how you have deployed the resources? Now, my lord, deployment of resources, my lord, is obviously, my lord, to be made all at a time, because ultimately, my lord, there's a time-bound, my lord, progress that is required to be achieved. And, my lord, here the contract stipulates, when I take your lordship to the contract, I should show contract stipulates that, my lord, time is of essence of the contract. My lord, naturally, my lord, in all these cases, it is mentioned to be of essence. Whether it is actually of essence or not is, my lord, another matter altogether. But, my lord, it is stated to be of essence. And, my lord, today, my lord, in the course of pre-bid queries, your lordship will find that, my lord, the requirement was that you will, my lord, mobilize all resources and make every endeavor possible to achieve, my lord, progress within the stipulated time. Because it was ultimately, my lord, the metro rail line that was to be established. My lord, here the response was that the presumption was I will deploy all my manpower and machinery together. You could have said that, I can allow you to demobilize certain men and machinery to use it for other sites, etc. But that call had never come. It is not on record. But, my lord, neither way, my lord, I said that my claim is not an account of idling of men or machinery. I did not say that I'm claiming because my men were sitting idle or my machinery was rendered idle. But I said that I have claimed on account of overstay in the contract. And, my lord, it's on account of additional establishment and other costs for which I have, my lord, relied on an established and time-tested, my lord, formula. Now, my lord, here, my lord, this is what the respondent submitted at 8.1.2. The respondent's contention submitted through CSF and surrejoinder as well as through presentation and response to questions. Well, this is what they say. The respondent has agreed that it has granted reasonable extension of time EOT to the claimant on their application, as was in the opinion of the engineer reasonable, duly considering the predicament in handing over work sites and other constraints causing delay in works. Well, this is an admission that, well, they have caused delay. Well, there was no delay occasioned on the part of the contractor. The respondent has submitted that the extensions granted on the aforesaid reasons mentioned by the claimant would not vitiate the contract, nor entitle the claimant to any claim any form of damages in terms of clause 8.4.1, read with clause 8.3 of the GCC. Inter alia, the claimant has waived their right to claim for cost overrun on account of delay due to the reasons prescribed under clause 8.3 of the GCC, as well as their unconditional acceptance of the EOT. Well, I'll just, my lord, come back to this, my lord, because I need to explain this a little better. But I shall not, my lord, trouble your lordship with this right now. I shall come back to it. As per the respondent, claim for cost overrun is ex facie contrary to clause 8.3, read with clause 2.2 of the GCC. The respondent has submitted that pleading for claims for delay due to employer's variation, diversion and restoration of chartered utility, removal of uncharted man-made obstructions and other extra works is unwarranted, as contractors are paid extra for such works, which obviously takes into consideration the additional establishment cost of the claimant consequent upon the extended time granted for execution of variation work. Now, my lord, this is completely, my lord, just a statement from the bar without any basis. My lord, basically what is being said that, any cost overrun that is, my lord, ultimately incurred by you is ultimately taken care of, my lord, by the employer's variation, diversion and restoration of chartered utility clauses. My lord, with the greatest respect, my lord, there is no basis or justification for this. That will be clear when I show your lordship the contract document. As per the respondent, the claimant had submitted a techno-commercial offer for positive variation of 695 crores to complete UG2 contract, which involves claimant's establishment costs with a letter number such and such dated 2015. Now, my lord, we are talking about 2019, my lord, 5 years extension. My lord, the question is, my lord, whether at that point of time I could have been in contemplation that, my lord, I will have to remain in sight for more than double the period of the original, my lord, contract period that was contemplated. As pointed out by the respondent, the claimant has claimed time overrun of 69 months commencing from April 2012, whereas Section 21 notice has been issued on 20th August 2018. And therefore, the claims prior to 3 years from such date shall be time-barred. Now, I again, my lord, was wondering, my lord, what was the basis of this contention, because it's a continuing contract where, my lord, bills are being raised, bills are being paid, and there's a continuous running transaction between the parties. Now, my lord, limitation is something, my lord, where, my lord, my right to a remedy is barred. My lord, law of limitation says your right is not, my lord, done away with, your remedy is barred. Now, my lord, today the remedy is barred when, my lord, I sit idle and do not make any claim or contention. Here, my lord, there's a running contract. Well, I cannot, my lord, ultimately put my finger on what is the total extent of delay. Unless I do that, my lord, do I make piecemeal claims on account of delay for the first year, delay for the second year, delay for the third year? But this is what is, my lord, contended. And I should show your lordship how, my lord, strangely it is dealt with. The respondent further submits that there was no idling of resources for this delay due to realignment affecting portion of Sialda to Central Station, as the tunnel boring machines deployed by the claimant, along with entire logistics and associated resources, were allowed to be demobilized after completion of tunneling work from Subhash Sarovar to Sialda, as per request of the claimant, and the remobilization cost for the same for execution of realignment variation portion of Sialda to Esplanade was allowed in realignment variation cost. The respondent, citing many Supreme Court decisions, a few of which have been enumerated, highlighted that arbitrators cannot make award capriciously or independent of contract provisions. Bharat Coking Coal and Alopi Prasad have been cited. I don't trouble your lordship with that right now. Then please have a look at paragraph Roman 10. Respondent has made the following submissions on the claimant's response to the questions asked by the arbitral tribunal. If the mobilization of man and machinery was not made in consonance with the program, it is obvious that the claimant cannot claim the unrecovered establishment costs on that account. Now, my lord, pausing here for a moment, they are trying to basically say that I am in breach of the terms of the contract, when they have, my lord, allowed extension of time, my lord, without any penalty, without any recourse. There is not a single incident where the consent asked for and denied by the respondent, after the demobilization of TBM has been consented and required charges have also been paid by the respondent. Deployment was not waiting at any point of time, and it was also not mobilized at once, but instead it was deployed phase by phase in consonance with the requirement at site. Now, if I've deployed it phase by phase in terms of requirement at site, the question is whether, my lord, my equipment was made available and was waiting to be deployed. The machinery and plant along with technical manpower is often being shared amongst phase 1 and the realigned portion of the tunnel and station. Same TBMs were under operation in realigned portion, and it was allowed to be demobilized on completion of tunneling from Subhash Sarovar to Sialda. No separate deployment has ever been done by the claimant at any point of time to construct tunnel 2. So, my lord, the essential argument was that there's a contractual bar under 8.3. Secondly, my lord, that you have not deployed men and machinery all at one point of time. Thirdly, is that, my lord, you were allowed to demobilize when you asked for it, because, my lord, you had to shift your tunnel boring machines from, my lord, different. Now, my lord, my lord, please have a look at now, my lord, the discussion with reasons. Well, I shall, my lord, go through this and then come back to, my lord, the contract and, my lord, my arguments. I just want to take your lordship through the award first. Arbitral Tribunal's discussion and decision. After studying the documents on record and listening to both the parties, all members of the tribunal have following points to mention regarding claim number 1. So, my lord, this is the discussion on my claim number 1. Both parties have agreed that there have been delays in completion of the assigned tasks by the claimant on account of delay in handover of work sites, traffic restrictions imposed by the Kolkata Traffic Police, and assignment of additional works due to employees' variations. So, my lord, 3 reasons are, my lord, recognized by the tribunal. One is, my lord, delay in handing over of work site, traffic restrictions, and, my lord, assignment of additional works due to employees' variations. Then, the respondent has aptly submitted that both the parties followed due processes of the contract contained in clauses 12.3, 12.4, and 3.5 of the GCC in deciding the variation process with necessary adjustment to contract price and time for completion. My lord, pausing for a moment. So, my lord, reference is made to 3 clauses of the contract to say that this is how the variation is, my lord, taken care of. My lord, naturally, if there's a change in the scope of work, either, my lord, work is reduced or, my lord, work is increased, my lord, it will affect, my lord, the total quantum that is to be paid, my lord, either by increasing it or decreasing. And, my lord, that is what variation is. Variation does not, my lord, ultimately cover, my lord, the cost of overrun, my lord, in stay, because, my lord, that is a separate component altogether. The cost of variation and the consequent time required for execution was determined by the engineer. Now, my lord, kindly marks these, my lord, expressions, which obviously would have taken into consideration the additional establishment cost of the claimant. My lord, this, my lord, use of the expression obviously is, my lord, a conjecture by the tribunal. Well, there is no definitive finding. So, my lord, the tribunal is here conjecturing without, my lord, reaching a conclusion. My lord, kindly see the cost of variation of work and consequent time required for execution was determined by engineer, which obviously would have taken into consideration the additional establishment cost of the claimant. My lord, what is the basis of, my lord, this, my lord, finding, my lord, we do not know. Consequent upon the extended time granted for execution of the additional works at additional price. The establishment would utilize for variation works during low activity in the main project. Again, my lord, this is, my lord, a statement made without any, my lord, reasons. It is only, my lord, a conclusion reached, my lord, without any reasons, my lord, backing up the conclusion. Then, my lord, please see again. Both the parties have agreed that unqualified EOTs, extension of times, were granted by the respondent after due process of review of applications submitted by the claimant. Again, kindly see, obviously, agreeing with the responsibility for delays by the respondent with due consideration to relevant contract conditions, that is 2.2 and 8.3. So, my lord, again, my lord, the entire realm is, my lord, within, my lord, the domain of conjecture. The respondent has submitted the claimant secured 695 crore work on a single tender basis and at updated price in December 2015 to complete the Underground 2 contract on diverted alignment, which would have held the claimant in better utilizing the establishment cost. In view of the above, nil amount is awarded against this claim, especially in view of the following. Now, my lord, with the greatest respect, my lord, up to this point of time, we find that, my lord, there is conjecture, there is no definite finding, there is no nexus between, my lord, what is, my lord, held and what is, my lord, the reason for, my lord, coming to the conclusion. And, my lord, here your lordship will find now, my lord, in view of the above, the nil amount is awarded against this claim, especially in view of the following. So, my lord, this is further justification for the nil award. EOTs have been granted on account of delays under clause 8.3 of the GCC, and the GCC clause 2.2 and 8.3 have very clear and explicit provision against damages and compensation. Now, my lord, so far as this is concerned, the attention is confined to 2.2 and, my lord, 8.3 without, my lord, any reference to, my lord, the pre-bid, my lord, meeting, without the, my lord, representation made in the pre-bid meeting, and other, my lord, provisions of the contract, including clause 3.5, which I shall show to your lordship. Then, my lord, kindly see, the claim is time barred. My lord, no discussion. No discussion at all. The claim is time barred. And then, my lord, notwithstanding with the claim being inadmissible, the method of calculation of the claim amount by the claimant is unacceptable. Now, my lord, so far as method of calculation is concerned, my lord, we have relied on formula, we have relied on chartered accountant's report, we have relied on documents. Now, my lord, none of these documents have been found fault with. It is not stated that the representation contained in the documents was false, untrue, or incorrect. But, my lord, they ultimately come to a conclusion that this is why it is not correct. Now, my lord, today I understand, my lord, I may claim 10 rupees. The tribunal may say that on an appraisal of the situation, on an appraisal of the records, on an appraisal of documents, I find you're entitled to 3 rupees. But when I say you're not entitled to anything at all, while accepting that, yes, there's a basis for calculation, but we don't accept your calculation. Now, my lord, if you don't accept my calculation, you have to say as to why you don't accept the calculation and what the calculation should therefore be. So, my lord, your lordship sees, my lord, conjecture, limitation, my lord, without any reasons, and ultimately, my lord, rejection of the entire claim, my lord, without any basis. Now, my lord, this is a very substantial claim, and it proceeds on an admission that there have been delays on the part of, my lord, the respondent, that is the employer, which has ultimately resulted in more than 5 years delay. Now, my lord, this is, my lord, really the basis on which claim 1 has been, my lord, rejected. My lord, claim 4, my lord, I shall show you lordship similarly. My lord, we are at 3:30, my lord. I don't mind going on for some time, but, my lord,
up to you.
I don't think anywhere else. My lord, may I come back? My lord, and, my lord, also, since your lordship has seen this, my lord, dealing with claim 1, none of the judgments that I referred to are dealt with or considered. I can understand dealt with, rejected, but not even considered in reaching, my lord, the conclusion. My lord, I wanted, my lord, this accommodation because, my lord, there are some pre-bid meetings, my lord, record of pre-bid meetings which should be a part of this compilation. But, my lord, there are so many volumes. I have not been able to identify that, my lord. I'll just, my lord, take this liberty of doing that.
Take that. Heard learned senior counsel, Mr. Vishnu Saha. Listed for further hearing. Full stop. Listed for further hearing. When do you want?
My lord, I must confess that I'm some. May I come back on the 2nd if it is not inconvenient for your lordship?
2nd December.
Since your lordship has started hearing it, I would like to continue also.
2nd December.
My lord, may I also file my reply to the affidavit in opposition that is filed?
एक लिखा है ना आगे जहाँ पे affidavit in opposition is taken on record. Reply to the said affidavit in opposition is also taken on record.